Good morning, everybody. Happy, weird, and wacky Monday. Welcome to TCF Live. You'll notice I didn't start out with a courtroom feed, but I'm going to. Don't worry, we'll get there. But I just wanted to explain, this has just been a weird morning already. In the pre-show, I showed a video that talked about how everything in the world is like broken. And then at the end of the pre-show, my computer started doing all sorts of crazy things, like opening tabs at random and everything else. So I had to restart everything. Everything appears to be working, so we're going to soldier on. If you see any issues during the show, let me know. I will try to correct them on the fly. And also, there is nothing, absolutely nothing of substance going on in Courtlandia out there at the moment. So we're going to start our day with part of Judge McNally's docket from Friday. As we await other courts to come online. But again, good morning, everybody, and welcome to TCF Live.
Discovery order.
All right.
Have a great day.
Thank you, Ted.
All right. People against. Jetto Sylvester Bagnon, 25F245-279. Okay, counsel. Wow. Come on up here. Your appearance?
Again, good morning, Your Lady. So, B67842, building up, Sylvester Jeton.
Ms. O'Brish, your name again?
Kim Howell, Chris, Your Honor.
You're still under oath.
Yes, Your Honor.
Sir, tell me your name. All right. He's going to plead to impeding traffic, correct? They're going to dismiss the drywall suspend. Is that right? Have you told him that? Okay. All right. To the charge of impeding traffic, do you plead responsible or not responsible?
Responsable, not responsible.
Yes. Responsible.
All right, tell him to slow down, will you please? Tell him I said to slow down. He's got some traffic record on here. All right, you got to slow down, sir. I'll accept the plea to impeding. 180 is your total.
Okay.
And the suspend is dismissed. Have a good day. Can he pay that today?
Yeah, we will have 2 weeks.
Pardon?
We will have 2 weeks to hear.
Yeah. I'll give him until the 19th. How's that? Counsel, tell him if he needs more time to call the court, not to ignore me. We'll go on Zoom. I'll give you an extension or no, it's kind of tough with the barrier. Maybe you could log on with him. You know what I mean? Okay, thank you. Have a good day. Good luck.
Thank you, Your Honor.
Thank you very much, Ms. O'Briss. I appreciate it.
That's not.
Eric Smith, Eric Raymond Smith. 26F245430. And could I have Eric Bagaya seated at the table, my right, your left? Have a seat at that table there, sir. Come on up to the podium, Mr. Smith. Your name?
Eric Smith.
All right, good. You're charged with driving on a suspended. You have the right to an attorney. If you want one, I will give you one. Do you want to?
That's the driving.
I'm sorry?
That's the driving. Take care of it.
All right, I'll go ahead and arraign you and send you to the prosecutor. It is alleged that you did on January 7 of 26 operate a motor vehicle in Flat Rock, they think with a suspended or revoked license. That is a misdemeanor punishable by up to 500 fines, 93 days jail, costs are all those 2 points. Do you understand that?
Yes.
You are presumed innocent. You have the right to a trial by court or jury. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court, to bring in those witnesses, to testify or remain silent. If you plead guilty, you're giving up all those rights. We're not going to have a trial. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand that?
Yes.
All right, I'll enter a not guilty plea. I'll give you a personal bond. You don't have to post any money, $500. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. You're going to go talk to the prosecutor and see what you can work out. And either way, you're coming back in front of me, okay?
Today, right?
Correct.
Okay.
All right?
Yes.
Go right out in the hall and the prosecutor will call you. Eric Tarenti Bergaya Jr., 26F262289. Mr. Bergaya, come on up here. Tell me your name, please.
Eric Bowman.
Okay, counsel, your appearance.
Good morning, Judge. Good to see you 2 days in a row. Patrick Nineheist, P76343, on behalf of Mr. Begoya, who's present in court, and I'm on Zoom, so thank you, Judge, for allowing me to be on Zoom.
We're just adjourning this, right?
Yes, Judge, but we wanted to address, I wanted to get a discovery order, which the prosecutor said was filled out, and you wanted us to come back so we could discuss modifying his bond to allow him to have non-assaultive contact with the victim.
I don't
due to
know.
their
So,
child income.
I wanted Ms. Denoyer here. I was hoping somebody would get her here. Maybe I wasn't very good about making that.
Prosecutor,
Can you come on in here, Mr. Cayley, please?
sure.
Thank you. So I've signed your discovery order. They will send that. They will email that to you. You have
Thank
an
you very
email
much.
address you can give me real quick?
Yeah, P as in Patrick, then my last name, NYENHUIS @gmail.com.
Mr. Cayley, your name?
Roger Kelly, I've got a big decision.
So I set this quick because this was a victim. They have minor children. I don't know if you ever had a chance or anybody over there had a chance to speak to the victim. I wanted to not require that he not be here or not be able to see his kids, but I'd like some input from the mother.
I've not heard from him.
You don't have Denson or Jarmo there in the room with you, do you? No.
No, Judge.
How old are the kids?
No, 3 and 1, sir.
Go ahead. You want to say something, Mr. Knight? I'm concerned about this. I'd like to at least get some input. I mean, I read the complaint.
Yeah, this was a pretty brief comment.
Yeah, so here,
He actually ended up, he was the one who called the police, Judge.
do you have any objection to me ordering that there's not to be any contact except to effectuate visitation?
No problem.
So I'm gonna go ahead and allow that, Mr. Nienhouse. We don't have to get too crazy here, but I want to be clear. Would you please call the police department and tell them I added that condition
Sure.
so that they can convey it to the victim? Try to wait till tomorrow at least, if you would, please.
Yes.
Your conversations with her are going to be limited to talking about when and where you can pick up the kids. You understand?
Yes, sir.
Judge also was asked, no assaultive or abusive.
Right, and that's gonna be added too, but I wanna be clear about that. I don't want you talking about this case. You're not to talk about finances. You're not to talk about anything other than when you're gonna pick up the kids, or she's gonna drop them off, and when you're gonna drop them off, or she's gonna pick them up, okay? I'll give you another court date, and I'm just asking that you wait until tomorrow to give her a call so that they can notify her. What do you have for me, Heather?
We could do February 19th at 10:15.
Good with you?
Judge, that should work for me. Thank you very much.
February 19th at 10:15 will be your court date. So you go down the hall, get your court date. And that's it. Okay? Understand everything?
Yes, thank you.
All right. Good luck to you. Thank you.
Thank you, Judge.
Thank you very much,
Thanks a lot.
Judge.
People again.
Good morning once again, everybody. TCF Live on a weird Monday. Happy to have you all here, though. Welcome again. You choose to spend your mornings with me, and that means a lot, and I want you all to know that, especially in a world that's just really kind of odd these days, as we covered in the pre-show. So, again, not a whole ton of significance going on in Courtlandia at the moment. However, Judge Tony Flores in Lansing, Michigan, has started his day, so let's peek in there, see what's going on.
Well,
Good morning, Your Honor. Joseph Gaming on behalf of Mr. Zimrai Redmond, who is present to my right.
And sir, you are Zimrier Arthur Alexander Redmond. All right, thank you. Is that a yes?
You got it right the
All right.
second time.
Okay. Make sure that we're on the right date.
Second one, ninth day, 2026.
Yeah, it's that 9 looks like a 0. All right. All right. How are we proceeding, Miss Fortuna Gill?
Your Honor, an offer has been extended to plead to an amended count 1 of assault and battery with an agreement, a sentencing agreement to no upfront jail. The PAT code for the A and B is 750.81. And it's my understanding the defendant wishes to avail himself of that offer. It's also my understanding that this would be a no contest plea.
Okay. And I'll ask Mr. Yang. It's a 90-day and/or
It's 93 days and or $500 fine.
93 days and/or $500. There's an agreement. Killebrew, no jail, and what is the purpose for the no contest plea, Mr. Yang?
Thank you, Your Honor. The purpose of a no contest plea is due to civil liability. Just for the record, what Ms. Fortuna Gill stated is correct as far as the offer and the sentence agreement.
All right, so it's an amended count 1, no contest, the amended count 1 of assault and battery, A and B, be a 93-day and/or $500. There's an agreement between the attorneys of no jail time, and the reason for the no contest is potential civil liability. And I have the incident report that we'll be using for the factual basis for the no contest plea. Report, it's 25-05437. Is that correct, Ms. Fortuna Gill?
Yes, Your Honor.
Mr. Yang?
Yes, Your Honor.
All right. All right. And that's your understanding, Mr. Redmond? Is that yes? Okay, thank you. This is the time set for a jury trial today. I'm going to walk you through some rights you have in this misdemeanor case. All right, sir?
Your Honor, may I approach briefly?
You may. Thank you, Mr. Yang. Sir, this advice of rights form indicates that you signed this. Is that correct? You signed the bottom of this? Okay, this goes through 12 of your rights concerning this. I will go through just the major ones, all right? You understand if your no contest plea is accepted, you're going to give up the following rights that you've indicated on this page, on this 2-page advice of rights. You're going to giving up the right to be tried by a jury, the right to be presumed innocent until proven guilty, the right to have witnesses appear in your defense, to remain silent, and to choose, and you can choose to testify if you wish. You understand you're giving up those rights. Okay. If your no contest plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record or threats it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial today, you'll be pleading no contest to the misdemeanor charge. Is it your wish today to waive your jury trial rights and plead guilty to plead no contest to the misdemeanor charge? Okay, thank you. I'm gonna have you. I don't have to swear you in because I'm taking the no contest plea. So for potential for civil liability, I indicated that the incident report is 25-05437. Mr. Yang was nice enough to highlight the various factions concerning the misdemeanor plea. This all occurred on, it's my understanding that this occurred on October 9th, 2025 at South Martin Luther King Boulevard, West Barnes Avenue in the city of Lansing, Ingham County. So that's the stated date and time. And it would appear that at that time, Larissa Ann Ralston School stated she was in the passenger seat. Mr. Redmond was driving. She's identified the defendant. There was a verbal argument. And it appears that there was an offensive touching committed by Mr. Redmond concerning this Ralston School. It looks like it happened in the parking lot of Frosty Corner, I mean, in the city of Lansing. And then there's various, but it looks like an offensive touching happened on that day and that time. Miss Larissa Ann Ralston School indicated that she was dragged, grabbed both of her legs, and that Mr. Redmond offensively touched her. Anything towards the no contest on the factual basis, Miss Fortuna Gill?
No, Your Honor, the people are satisfied.
All right, Mr. Yang.
Nothing from the defense.
All right. I find that the LPD report for the factual basis be knowing, voluntarily, and accurately made. That's just that's for me. The no contest plea. And we'll refer to probation. There is an agreement between Mr. Yang and the people of the state of Michigan that you not receive any jail time in this matter. If I was going to do something different from that, you'd have the opportunity to withdraw your plea. Do you understand that, Mr. Redmond? Okay. All right. So you should go one, probation's 1 floor down, all right? And we're gonna refer to probation, they can do a report for me, so we'll see what options are available to us. The probation department will either see you today or set up an appointment to see you. And then our sentencing will be sentencing date of about 8. We're doing sentencings at about what?
I think it's usually 6 weeks.
It's about 6 weeks. Yeah. Because they're gonna have to, yeah, and for drunk driving, the assessment may be longer, but 6 weeks, I think, is what probation's asking for. March 23rd at 1:30. All right, so let's see what options are available to us on March 23rd at 1:30. Anything else for the record in docket 250308, Ms. Fortuna Gill?
Not for the people.
Mr. Yang?
Nothing from the defense, Your Honor. Thank you.
All right, Mr. Redmond, we'll see you on that March 23rd date at 1:30. Thank you for your appearance today.
Once again, good morning, everybody. Happy Monday to you. It is TCF Live. It's good to have you all here. I'm going to eat some breakfast. I got some scrambled eggs and some homemade kimchi that I made a big batch of this weekend. Let me know what you're having or have already had. Breakfast is good. Let's stay in Michigan, but Judge Elmore's opening up his day. Let's see what's going on there.
And then see how you wish to respond. On this requested warrant, it alleges 4 counts of violating the terms and conditions of your probation. Count 1 alleges that you violated special condition 2.0, which requires that you must not use or possess alcohol or other intoxicants. And more specifically, it's alleged that on or about February 3rd of this year, you used and or possessed alcohol. Count 2, 3, and 4 each allege a violation of Rule 1. Rule 1 of your probationary terms requires that you are not to violate any criminal law of any unit of government. For count 2, it alleges that on or about February 3rd of 2026, you operated a vehicle while intoxicated and or impaired. Count 3 alleges that on or about February 3rd, 2026, you operated a vehicle without insurance. And count 4 alleges that on or about February 3rd of 2026, you possessed open intoxicants in a vehicle. You have the right to challenge those 4 allegations at a contested hearing. That hearing would occur within 14 days from today's date. At that hearing, you'd have the right to be represented by an attorney, as well as at all subsequent proceedings. You'd have the right to have the prosecutor prove the allegations by a preponderance of the evidence. You also would have the right to review the evidence against you, question or cross-examine any witnesses presented against you, as well as the right to present witnesses, evidence, or testimony if you chose, and also the right to remain silent and the right to not have that silence used against you. If you cannot afford an attorney, the court will have a public defender appointed to assist you. If you're found to be in violation of your probation, you'll be resentenced on your original offenses. In this case, you were originally convicted of aggravated assault. That is a misdemeanor. Misdemeanor punishable by up to 1 year and or up to $1,000. You were also convicted of attempting to resist assault or obstruct a police officer. That would be a misdemeanor punishable by up to 1 year and or up to $2,000. And you are also convicted of malicious destruction of personal property in a value of less than $200, which itself is a misdemeanor punishable by up to 93 days and or up to $500, or 3 times the amount or value of the property that was damaged or destroyed. Because there are 3 non-technical allegations, the court is not limited to a sliding scale. For what are called technical probation violations, the court is limited to a sliding scale of 5 days, 10 days, and 15 days for your first, second, or third. However, because you are charged with 3 non-technicals, if you were found guilty of 1 or more of those 3, the court again would no longer be limited by the amount allowed. Would not be limited by the sliding scale, but would only be limited by the amount allowed under the law for the 3 offenses. Now, based upon these allegations, I suspect you have been charged criminally in another courtroom. Mr. Van Atwell, do you know if there have been any new charges filed based upon these alleged acts?
He was arrested on the 3rd, but released on a PR bond because he had to get evaluated medically, and he has court in 85th District on 219.
Okay. All right.
So he's charged, but
on bond.
Yes.
All right. So, Mr. Rocheleau, that means that if you request an attorney, I'll of course have one appointed, and I'll enter a not guilty plea. If I enter the not guilty plea or you enter the plea of not guilty, either way, we'll set it for an informal hearing. That hearing could take place later this week. However, I will tell you that I have a trial that's going to probably take the full next 3 days. So there's a good chance we wouldn't get to it until next week. At an informal hearing, the attorneys and you and Mr. Van Atwell will appear in front of the court and tell me what's going to happen. Are we going to have a contested hearing? Is there going to be a plea or resolution, or are the allegations going to be dismissed? I won't know that until we get to the informal hearing. Now, if there is no resolution at that informal hearing, we will have it set for a contested hearing, which is again in the courtroom where there would be witnesses. Generally, those take about 30 minutes to go through. Also, you want to keep in mind that anything you say today or in the processing of this case could be used against you in Benzie County. So you want to be very careful about not making any statements today that would be inculpatory or could be used against you. Now, so far, do you have any questions about what I've advised today?
No, Your Honor.
And do you wish to have the court appoint an attorney to assist you?
Yes.
The court therefore enters a not guilty plea on behalf of the defendant and will refer the matter to the Western Misaki Public Defender Program for the appointment of an attorney. Now, the next question becomes, what does the court do with the defendant in the meantime? Mr. Rocheleau, I've been told that you had some kind of medical appointment or something. Have you had, or you needed one? Did you have that already?
Yes.
Right. And Are there any other appointments set in the next week?
No, Your Honor.
All right. Your position, Mr. Van Atwell, I don't know if he's had any other probation, but I don't see any tabs here, but in the file, but have there been any other probation violations?
There's one prior PB acknowledgement for failure to pay fines and costs.
All right.
He did turn himself in to the probation department on the 6th,
Okay.
last week Friday, expecting to go to jail. So
All
just
right.
based on that, I would not be opposed to some type of bond.
Mr. Oshlu, what is your bond out of Benzie County?
I'm not sure. They just gave me a ticket and then gave my belongings, and then that was when I was in Munson Hospital, so I don't know.
You told me there was a PR bond. Yes, I'm sorry. Mr. Van Atwell had already told me that. Thank you. Did they have you sign up for breath tests or anything else like that?
No, Your Honor.
You still residing at this address on 39 Road up in Manton?
Yes, Your Honor.
Are you working?
Not anymore.
Okay. And with whom do you reside at that address?
My sister.
Do you have any prior drinking and driving convictions? In other words, it tells me if it's a, all right. And so up in Benzie, are you charged with a drinking and driving first, second, or third?
Second.
So does that mean you only have one prior drinking and driving?
Yes.
All right.
As far as I'm aware, he has one prior, which occurred prior to his placement on probation in this case.
Yeah.
But it was resolved while he was on probation in this case.
Okay. That just tells me, Mr. Oshlu, that you aren't facing a felony. That's why I was asking that question. Okay. What were his guidelines here, Mr. Van Atwell?
There's no sentencing guidelines. You know that.
Oh, it's right. It was a misdemeanor. Thank you. Oh. All right, the court will set a bond in this file at $500. The court will add the terms or conditions that he is not to use or possess any alcohol or controlled substances. And that he'll be subject to random testing through the Community Corrections Office. Also, he must enroll. Well, we're going to get this generally done within a couple of weeks. EOP program probably wouldn't even be advisable because you wouldn't get it into it before this was resolved. So, all right, I'm not going to add any other term or condition. He's not to consume or possess alcohol or other intoxicants and be subject to random testing through Community Corrections. All right, anything else, Mr. Van Atwell?
Thank you.
All right, Mr. Rochelu, make sure, I'm sorry, is your telephone number, sir, still the one that ends in 6355?
Yes, Your Honor.
Thank you. All right, we are adjourned.
Okie dokie, friends. Let's got some courts starting to come online finally. Let's stay in Michigan, but go to Judge Mom. Say good morning to her.
Court will amend we'll grant that amendment. That's $175. Is your client paying that today?
Could I ask for 24 hours, Your Honor? She's prepared to pay, but just so everything gets in the system properly. Your Honor, that would be a plea of responsible to impeding traffic. Am I correct on?
Yes.
Thank you.
And then the original charge of being dismissed.
We'll have her pay within 24 hours.
Okay, all right, thank you. Have a good day.
Okay.
All right, we are on the record in the matter of the City of Riverview versus Daniel Calipari, 251586 A and B.
Good morning, Your Honor. Mr. Jeff, preparing to act my client stands my legal right. Sir, can you state your name for the record, please?
Dan California.
Okay, so today is the date scheduled for the adjourned pretrial.
Yes, Your Honor. This is nothing to do with the neighbor. This is specifically relatively associated with the blight issue. There's bricks being removed as they violate enforcement code. That being said, with the weather, those bricks are frozen. My client is unable to move them. In the circumstance, we're respectfully requesting consideration for the weather breaks so that he can be in a position to use the brick that are violated.
They're frozen?
Yes, Your Honor.
Your Honor, can I explain? You can't lay bricks when it's when it's this cold. The mortar, you can't.
So you can't lay them or you can't move them?
There's bricks that have to be replaced. So, the mortar has to have a decent temperature to work with.
No, I'm aware of that, but so that's what I'm trying to get clarification on. Because from what I understood, part of your house is missing bricks.
Yes.
And you need to put them on, you have to put the bricks on.
Yes.
So my confusion is when it says that bricks are frozen and they can't be moved.
It was a misstatement, I think. You can't work with mortar when it's this cold. So the bricks that need to be relayed can be done with this temperature.
Well, that's also interesting because I know plenty of bricklayers who are still out laying brick in this temperature.
Yes, Your Honor, there are. I have to do it myself. I hired a guy to do this work.
So if you have to do it yourself, sir, there's been days where it's been acceptable for the mortar. Or acceptable temperature for it to be done. So my question is, why wasn't it done during that time?
Or possibly the project's been a nightmare. I got robbed of $3,000 hiring 2 contractors that did a terrible job.
Okay, well, here's the thing. So now it's already been adjourned 30 days. We've already adjourned it once 30 days, and now there's a request to adjourn another 45 days.
So that the weather will be a decent temperature, and it still might not be a decent temperature even in March. Last year was below freezing most of the month of March.
Well, sir, what is your plan then? Because I'm not going another 45 days. That's way too long to go after. So then that's going to be sometime in March on this matter that's been pending since November is when the original notice was mailed out. And you were here January 12th.
Which, by the way, that was a complaint by the neighbor also. After.
I'm not worried about what the complaint was made. Who made the complaint? At the end of the day, you don't have the bricks on your home that you're supposed to have on your home. Sorry to cut you off, Mr. Sharkey.
I just want to keep on target.
Correct. Okay, let's see here.
Your Honor, I have insulated, put a layer of a wallboard over the insulation, and then I put a Tyvek. And so now the layer of bricks needs to be done. And there's probably only about 100 bricks that need to be done. But basically, about 2 foot or 3 foot up to the ridge line of the roof.
And so what are you indicating is the ideal temperature, Mr. Calipari, to do that?
I'm just like above freezing for more than 24 hours. 24 hours. But again, it's a whole project. It's not, you may only lay 1 or 2 courses in a day. I'm not a bricklayer, so there's just only so much that I can do.
Well, great. Over the next week, it's going to get up over 34, 38, 36, 43, 40 degrees. So you can do it then, next week. So I'll give you a 21-day improvement.
It's not a one week project. It really isn't.
Well, sir, this seems to be something that's been pending for a while, even before you were issued the citation, and it's not done. So I'm going to adjourn it for 21 days and see where you're at. Bless you.
And what you have to do is do a siding project instead of a brick project.
What do you mean?
In other words, not do bricks, do siding and P111 siding kind of thing.
Okay, if that's what you choose to do, but the issue has to be resolved, whichever way you choose to resolve it.
That's the only way it could be done right now.
Well, sir, if you're able to do it, right, and you want it to be above freezing, that's going to happen over the next week or so. So you can certainly still do bricks over the next week or so. I may not look like I know what I'm talking about when it comes to masonry, but and I know that there are many people that are doing outside brick and mortar work, stone work, all of it, block work, and they're still laying it. I believe that you can even get mortar for weather specific levels.
What's a witness, please? Oh.
We'll adjourn this to March 2nd.
No.
9:15 a.m.
Your Honor, I would like to be on record to say that this is a complaint brought after you told my neighbor to leave me alone. On October 27th, you told the neighbor to leave me alone and my family. Since then, he's gone in front of the council and complained about you and me and written letters on the internet.
Okay, that's fine. Record made. The court will also note that you also were not leaving Mr. Moss alone either. Whether he was recording you or not, you left your home, walked over to the video. I saw that. I saw that as well. So I had ordered no contact, is what I had ordered.
There was no.
And so, and I've also, it appears as though Mr. Moss has been complying with the court's latest order, where he is not to be interfering with any work or otherwise that you are doing in the back of your home. And so whether it's Mr. Moss, whether it's another neighbor, I don't know. But at the end of the day, sir, you've been issued this citation because your home is not finished appropriately. So let me just see here something. Okay, so sir, just to confirm, I wanted to confirm what I thought was correct, right? Is that you can lay bricks in temperatures below 30 degrees, but there are certain cold weather procedures. So make sure you're following those procedures and you can get it done. It should have already been done.
Your Honor, it's been 7 degrees all month.
No, it hasn't been 7 degrees all month. There has been days where it's been cold, sir, right? Frigid cold, below zero, whatever it may be. It's not been the entire month. Did you have anything ready and prepared
Yeah,
to lay the brick with cold weather procedures? Because when you were here on January 12th, there was an adjournment of 30 days. Did any of you look at the weather prediction when you indicated 30 days it would be done? Yes or no?
At that time, the weather was pretty good.
Yes or no? Did anybody look at the weather
No,
projection?
no,
Okay,
no.
well, you indicated it would be done in 30 days. So now I'm giving you 3 more weeks for it to be done.
Thank you.
You're welcome.
Judge.
Thank you.
So two things can be true at once here. First, he's got a lot of excuses, and if he agreed to 30 days, he agreed to 30 days. However, what he's saying about cold weather and mortar is not wrong. They have additives and stuff you can put in mortar to help it quote-unquote cure in cold weather, but it affects the longevity of it. So if he does this work, it's not going to be good lasting work in the cold weather. So I don't know what the solution here is, but two things obviously true at once. Let's, since Judge Santo just cut her feed, let's not go back to her. Let's go to Wade Mercer.
Good morning, Mr. Pacheco Robles. Mr. Ricardo, if you please introduce yourself to him first, make sure he can see and hear you.
Yes, Your Honor. Muy buenos días, señor Pacheco Robles. Mi nombre es Jordani Ricardo. Soy intérprete para que se pueda comunicar con el juez. ¿Usted me escucha y me ve?
Okay.
Okay.
So you're here because you've been charged with one count of driving with no valid driver's license.
Usted está aquí porque tiene un cargo de manejar sin licencia de conducir válida.
I'm going to appoint the public defender's office to represent you this morning.
Le voy a asignar la oficina del abogado de oficio para que lo represente esta mañana.
I have read the complaint and there is probable cause.
He leído la denuncia y hay causa probable.
Mr. McDaniel, were you able to communicate any with Mr. Pacheco Robles?
¿Y señor McDaniel se pudo comunicar con el señor Pacheco Robles? Sí.
Sir, I'm going to ask that you listen to your attorney, Mr. McDaniel.
Señor, le voy a pedir que escuche a su abogado, el señor McDaniel.
All right, I spoke to Mr. Pacheco. He's going to plead no contest. The charges listed. The understanding he'll be sentenced to 10 days in the county jail. He'll have a $400 purge, 1 day jail credit.
Su señoría, hablé con el señor Pacheco Robles. Él se va a declarar, no me opongo ante los cargos, entendiendo que se le va a condenar a 10 días en la cárcel. Tendrá una purga de $400 y tendrá crédito por 1 día en la cárcel.
Signed a plea waiver form, waiving his right to jury trial and call witnesses, and understands that any plea can result in immigration taking him out of the country.
Y él ha renunciado a su derecho a un juicio con un jurado, a llamar a testigos, y él entiende que este acuerdo puede significar que inmigración lo saque del país.
Mr. McDaniel, does he understand that he can't be released until noon today if he makes that purge?
If you would just
Y señor McDaniel, usted entiende que a él no se le va, él entiende que él no va a quedar libre aunque pague la purga hasta después del mediodía hoy, si se lo pudieran explicar.
After communicating with both of them, I don't know if they're going to be able to pay a purge, or if they do, it'll be after 12, no matter what.
Y después de hablar con los dos, no creo que van a poder pagar la purga, y si la pueden pagar, de todas formas no va a ser antes de las 12, va a ser después.
Mr. Pacheco Robles, the jail information does not have a social security number for you.
Señor Pacheco Robles, la información de la cárcel no tiene un número de seguro social para usted.
So when that happens, we'll hold the individuals until noon to see if immigration does place a detainer on you.
Cuando eso pasa, mantenemos a los individuos detenidos hasta el mediodía para ver si inmigración le da una orden de retención.
I have no idea if they will or not, but as of noon today, Central Time, you can make that purge if you want to and be released.
No sé si lo harán o no, pero después del mediodía de hoy, de hora del centro, puede pagar esa purga y quedar en libertad.
Mr. Mitchell, is that agreeable with the state?
It's all agreeable with the state, Your Honor.
Señor Mitchell, ¿está de acuerdo el Estado? Completamente de acuerdo su señoría. Before?
I'm sorry, is that what he said before? Are you talking
Yes,
to me?
Your
Is that
Honor.
what he said?
Yes, Your
Okay.
Honor. The interpreter.
Yeah, Mr. Pacheco Robles, do you have any questions about that agreement? Let's do it this way.
Señor Pacheco Robles, ¿tiene alguna pregunta acerca de este acuerdo?
Sí.
Yes.
Tengo la manera de pagar, pero porque no entendí muy claramente que si puedo pagar ahorita, puedo salir o no puedo salir, no sé.
Yes, I do have a way of paying. It just wasn't very clear to me whether or not I could go ahead and pay already or if I would be released or not.
You will not be released until noon today, even if you pay before then.
No va a quedar libre hasta el mediodía de hoy, aunque pague antes.
If you have made the payment at noon and there's no
Okay.
immigration hold, you'll be released immediately.
Si para el mediodía ya ha hecho el pago y no le han dado una orden de retención de inmigración, inmediatamente se le dejaría salir.
What you may want to do is wait until noon to make that payment.
Lo que quizás quiera hacer es esperar hasta el mediodía para hacer el pago.
Because if the immigration places a hold on you, I'm going to see you tomorrow anyway.
Porque si inmigración le da una orden de retención, yo como quiera lo vería mañana.
So if they don't place a detain on you by noon, feel free to post the purge and you'll be released.
Así que si para el mediodía no le han dado la orden de retención, siéntase en libertad de pagar la purga y lo dejan salir.
If they do place a detainer on you, it's very possible the offer may be changed tomorrow to time served instead of 10 days.
Si sí le dan una orden de retención, es muy posible que mañana le cambien el acuerdo que le ofrecen a tiempo ya cumplido en vez de 10 días.
Any questions?
¿Alguna pregunta?
De cualquier manera tendría que pagar.
In any case, I would have to pay.
If it's changed to time served tomorrow, you would not have to pay. It would be a civil judgment.
Si mañana se cambia a tiempo ya cumplido, no tendría que pagar. Sería un fallo civil.
Any other questions?
¿Tengo algún otro cargo?
Okay. Are there any other charges pending against me?
Not that I'm aware of.
Que yo sepa, no.
Okay. Está bien.
Very
Yo
well.
tengo que esperar de mediodía en adelante para hacer mi pago.
So I have to wait until afternoon to make the payment.
Noon. That is about 3 hours and 15 minutes from now.
El mediodía, como 3 horas y 15 minutos desde ahora.
Knowing all of that, is this the plea you would like to enter?
Sabiendo todo eso, ¿es este el acuerdo que desea aceptar?
Sí.
Yes.
Mr. Pacheco Robles, I'm going to accept your plea of no contest to the charge of no valid driver's license.
Señor Pacheco Robles, acepto su declaración de no me opongo ante el cargo de no tener licencia de conducir válida.
I'm going to sentence you to 10 days in jail with a $400 purge.
Lo voy a condenar a 10 días en la cárcel con una purga de $400.
You can make that purge as of noon today.
Puede pagar esa purga a partir del mediodía de hoy.
If the immigration does place a detainer on you, I will see you again in the morning and we'll reevaluate it.
Si inmigración le da una orden de retención, lo volveré a ver en la mañana y reevaluaremos esto.
But if they haven't placed a detainer on you by noon and you make that purge, you'll be released immediately.
Pero si no le han puesto la orden de retención para el mediodía y usted paga la purga, inmediatamente lo dejarían salir.
Do you have any questions?
¿Tiene alguna pregunta?
Sería todo. Muchas gracias al juez.
That's all. Thank you so much, Judge.
Have a good day, sir. You're welcome.
Que tenga buen día. De nada.
We have Alvaro de Leon Orozco.
Bien, tenemos a Álvaro de León Orozco.
And Sir, good morning. You're here for charge of driving with no valid driver's license?
Buenos días, señor. Está aquí bajo el cargo de manejar sin licencia de conducir válida.
I have read the complaint and it does contain probable cause.
He leído la denuncia y contiene causa probable.
I'm appointing the public defender's office to represent you and asking that you listen to your attorney.
Le estoy asignando al abogado de oficio para que lo represente y le pido que escuche a su abogado, el señor McDaniel.
Okay.
Okay.
Your Honor, we're going to enter a plea of no contest. The charge is listed. You understand he'll be sentenced to 10 days in the county jail. He'll have 3 days jail credit. He can be released from jail by paying the sum of $400 at the clerk of court.
A su señoría, nos vamos a declarar no me opongo. Él entiende que se le va a condenar a 10 días en la cárcel, que tiene crédito por 10 días y que puede quedar libre pagando la cantidad de $400 en la oficina de la Secretaría Judicial.
Waived his right to a jury trial and call witnesses and understands that any plea can result in deportation.
Él ha renunciado a su derecho a un juicio con un jurado, a llamar a testigos y entiende que cualquier tipo de acuerdo en un caso penal pudiera resultar en la deportación.
Mr. Mitchell's out agreeable with the state.
It is, Your Honor.
Señor Mitchell, ¿está de acuerdo el Estado? Lo está su señoría.
Mr. De Leon Orozco, did you hear that agreement?
Señor de León Orozco, ¿escuchó el acuerdo?
Sí.
Yes.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
Sí, tengo una pregunta. Aquí voy a pagar el dinero, pero lamentablemente que yo no tengo aquí. Tendría que mi familiar que venga a pagar por mí.
Yes, I have a question. I'm going to pay the money here, but regrettably, I don't have it with me, so a family member would have to come and pay on my behalf.
You'll get to use the phone. What is your question?
Le van a permitir usar el teléfono. ¿Qué pregunta tiene?
Mi pregunta es que yo tengo guardado algo de dinero en mi casa, pero yo vivo en Montgomery, Alabama. ¿Será que puede venir mi familiar a pagarlo aquí?
So my question is, I do have some money put away at home. The thing is, I live in Montgomery, Alabama. Can one of my family members come and pay that here?
At the clerk of court's office in Jackson County, yes.
En la oficina de la Secretaría Judicial en el condado Jackson, sí.
But did you hear what I explained to the last gentleman about you being held until noon?
Pero ¿escuchó usted lo que le dije al señor anterior en cuanto a que se le mantendría detenido hasta el mediodía?
Sí.
Yes.
Yeah.
The same thing applies to your case also.
En su caso le aplica lo mismo.
Do you have any other questions?
¿Tiene alguna otra pregunta?
Solo eso.
That was it.
Is that the plea you would like to enter, sir?
¿Es este el acuerdo que desea aceptar, señor?
Sí.
Yes.
I'm going to accept your plea of no contest to the charge of driving with no valid driver's license.
Acepto su declaración de no me opongo ante el cargo de manejar sin licencia de conducir.
Withhold adjudication of guilt and sentence you to 10 days in jail with 3 days credit.
Lo condeno a 10 días en la cárcel y le doy crédito por 3 días.
However, you can purge that sentence and be released immediately by paying court costs and fines totaling $400.
Sin embargo, puede purgar esa sentencia y quedar en libertad inmediatamente pagando multas y costas de $400.
And you can do that at any time after noon today, as long as they're open.
Y puede pagar en cualquier momento después del mediodía hoy, siempre y cuando estén abiertos.
Mr. McDaniel, is Mr. Pacheco still in the room also?
Y señor McDaniel, el señor Pacheco también está en el cuarto ahí todavía.
No.
He's on the telephone.
Ya está hablando por teléfono.
Just to understand, sir, that the purge has to be made at the clerk of court's office, not at the jail. Understand that.
Solo entienda, señor, que la purga se paga en la oficina de la Secretaría Judicial, no se paga en la cárcel. Entienda eso.
And it can be made in person or over the phone with the clerk of court's office.
Y la pueden pagar en persona o también pueden pagar por teléfono con la oficina de la Secretaría Judicial.
So you may want to wait until noon to see what immigration does and then make the decision about posting the purge.
Entonces quizás quiera esperar hasta el mediodía para ver qué hace inmigración y después decidir sobre la purga.
If immigration does place a hold on you, I will see you in the morning.
Si inmigración le da una orden de retención, yo lo vería por la mañana.
Do you have any questions?
¿Tiene alguna pregunta?
¿Se puede pagar por la línea entonces?
So it can be paid online then?
It can be paid, no. It can be paid in person or by telephone.
No, se puede pagar o en persona o por teléfono.
Oh, okay.
Oh, okay.
¿Entiende?
Okay.
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 Thank
Have a good day.
Que tenga
You're
buen
welcome.
día.
Thank you, Mr. Ricardo.
Thank you, Your Honor.
We've got a couple of people that have friends or family here, so let me take those cases next. The first is Caden Revels. Mr. Revels, good morning. Your father's in the courtroom. Mr. Revels, you're here because you've been accused of 5 charges. You've been accused of 1 count of possession of altered firearm, 1 count of concealing a firearm under the age of 21, possession of firearm during the commission of a felony, possession of marijuana over 20 grams, and aggravated assault with a firearm. There is probable cause for 3 of those charges for sure. The possession of marijuana over 20 grams, and the possession of firearm during the commission of a felony. I'm not sure there's probable cause on because the officer didn't identify the type of test he chose to use in this case, which is a problem. Mr. McDaniel, are you wanting to waive that for first appearance purposes so I can go ahead and set Mr. Revels a bond?
Yes, Your Honor.
Okay. Mr. Mitchell, I'm going to ask you to notify the deputy again. This has been the law now for about 5 years, and we shouldn't be seeing these anymore. But he's got to distinguish that he's got to put in the complaint that the test he uses distinguishes from hemp, which is legal, and marijuana, which is not legal. And the officer doesn't do that in this case.
Yes, Your Honor.
Mr. Revels, the criminal history I've got shows no prior criminal history. Is that accurate?
Yes, sir.
All right, perfect. And how old are you?
19.
Okay. And you live with family? You live by yourself? What's your living situation?
I live with family.
And you work at T4 Pole Barns, is that right?
Yes, sir.
Where's that out of?
Bristol.
Okay. Let me see if the attorneys have any additional information before I address your bond. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
We just request that that he not have any that he not possess a firearm, and if you want to go ahead and set a bond on the marijuana charge, you could treat it as a misdemeanor bond, and we would request random UAs.
Thank you. Mr. McDaniel, what's your position on not possessing a firearm?
I don't think. Your Honor, we're fine with that while the case is going forward.
So, Mr. Revels, considering your criminal history, your lack of criminal history, I'm going to set you the following bonds: the possession of altered firearms, a first-degree misdemeanor, as is the concealing a firearm under the age of 21. Those bonds will be $2,500. The possession of firearm during the commission of a felony is actually a second-degree felony, but given no criminal history, I'm going to treat it as a third degree for bond purposes. So that bond will be $5,000. The remaining 2 well, actually, no, the possession of marijuana over 20 grams will be a $2,500 bond. Mr. Mitchell's agreeing to treat it as a misdemeanor for bond purposes. And ag assault with a firearm is a third degree felony. That'll be a $5,000 bond. Mr. Revels, when you add those together, your total bond is?
I think 17.5 is what I got.
17.5. $17,500 is your total bond, cash or surety. Mr. McDaniel, he's not requesting a cash bond. Is that correct?
I have not talked with him about it. I don't know if the family has the money or not. His father, I don't know if you can ask him.
So, sir, while he's talking to your son, do you understand how a bond works? Okay, so his bond is $17,500. 2 ways he can do that. One is if the family is able to put up all $17,500, he gets it. He gets out, and when he completes all his mandatory court appearances, the money is returned to whoever posted the bond, unless there are court costs and fines imposed. Under Florida law, if there's court costs and fines imposed, then that money has to be taken out of the bond. The other option for a bond is he goes to a bondsman, or you go to a bondsman for him, and the bondsman agrees to accept a percentage of the bond, and they vouch for his appearance. And that percentage is usually around 10%. With his history, they may take 5% up front. That's something you negotiate with them. But that would be $1,750. Here's the trade-off. You don't get that back. That is their fee. You would be spending $1,750. So what I may do sometimes with someone with no prior history, like himself, is offer them a $1,750 cash bond. Here's why that's important. If you choose a $1,750 cash bond, you still have to put up $1,750. But as long as he makes his court appearances, you get it all back. The other thing about putting up $1,750 is what I said earlier is still true. If there's court costs and fines imposed, it comes out of the $1,750. So if there's $1,000 court costs and fines, they're going to go towards his court costs and fines by state law. If the case against him is dismissed, then the $1,750 cash bond is returned to whoever posted it, all of it. Okay, so some people prefer a cash bond if they can put up the full $1,750. Do you have? I know he's going to want to know your. I would think he's going to know your suggestion. Do you have a suggestion for him at all on which he chooses?
I'd rather try to do 17, but I don't know if I'm going to come up with.
Understand. That's a lot of money. Okay. Mr. McDaniel, you heard what the father said. Anything else on behalf of the defendant?
No, nothing, Your Honor. Mr. Rebels indicated the same thing to me, so we'll just, right now.
Treat it as a normal standard bond.
How much can you come up with, Father?
I don't know that I want him sitting there with these charges with no history. What if I make it an even $1,000 cash bond? Is that more likely something you can come up with to get him out, sir?
Probably have to call our boss.
Okay. Mr. Mitchell, with his history, any objection to that?
No objection, Your Honor.
So let's do this. Let's do $5,000. Let's do $500 cash on the two on the ag assault and the possession of firearm and commission of a felony and ROR on the other three charges. You got a total cash bond of $1,000. I'm trying to set that amount that he can make. He's got a condition of random urinalysis. That means he can be drug tested. And he's got a condition that he not possess any firearms based on his age and his charge. So it's $1,000 cash. And then, as I said, if there's court costs and fines imposed, that $1,000 may go towards court costs and fines. But if he gets into this case and it gets dismissed, then the money's returned to whoever posted the bond. Any questions? All right, your dad's going to try to do what he can to see if we can get that posted, so you hopefully you can get out of there. But you know, you've got some serious charges. You've got one second-degree felony potentially, which is very serious. Any questions, Mr. Revels?
No, sir.
All right, wish you the best. Thank you for coming,
Yes,
sir.
sir.
We have friends or family here on Abby Malloy. Free to go. Wish you the best, sir. Thank you. Ms. Malloy, good morning. Ms. Malloy, you're here for the charge of violation of county probation in case 25-479 CT. Ms. Malloy, I'm appointing the public defender's office to represent you. I'm asking that you listen to Mr. McDaniel, ma'am, on this allegation against you, and your stepfather is in the courtroom, sir. Mr. McDaniel?
Yes, ma'am. Yes, Your Honor. His court date's going to be, I think, March 3rd if the father's still in there. He's been in the courtroom March 3rd.
Thank you.
Yeah.
I thank you. I absolutely forgot that March 3rd at 9 a.m. be his court date. Thank you, James, for telling him. Ms. Malloy, listen to Mr. McDaniel, please.
Your Honor, I spoke with Ms. Malloy. She's going to admit she violated probation. Your understanding should be sentenced to 10 days in county jail. She'll have 3 days jail credits, and that'll resolve this case this morning.
Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Malloy, did you hear that agreement, ma'am?
Yes, sir.
And Ms. Malloy, is that the admission you would like to enter?
Yes, sir.
Ms. Malloy, I'm going to accept your admission that you violated the terms of your conditions of your probation, ma'am. I'm going to revoke that probation, sentence you to 10 days in jail, adjudicate you guilty, ma'am. I think you got everything done except unable or unwilling to give a urinalysis, and that's the sole basis for the violation. So, ma'am, you have 7 days left at most. And the reason it's such a short sentence is because you did everything else, as far as I can tell. Mr. Goodson shaking his head, yes, you did everything you're supposed to except that last thing. So, ma'am, you finish this 7 days you have left. You'll be done with this case. There's no probation remaining. And I'm going to continue actually, what I do on the adjudication, she's got a couple of old worthless checks is all she has. Any objection to me continuing to withhold, Mr. Mitchell?
Let me see. What was the original charge? Yeah, no objection.
So I may have said adjudicate, Dawn, but we're going to withhold adjudication guilt, continue that withhold that was imposed originally when she was sentenced to probation. So I'm talking to your stepdad now. So, sir, what that means is she has 7 days left at most. She may do 5 or 6, depending upon gain time, but at most she'll do 7, and she's got no more probation. Do you have any questions? She's got everything done, right? She got everything paid. She did everything she was supposed to, except the drug test. Any questions? Ms. Malloy, do you have any questions?
No, sir, just tell my son and my father that I love him very much, and I thank you so much for being there.
I don't know if you could hear him. He said everything's good, and he's in good hands. Your son's in good hands. Okay, ma'am? Have a good day, Ms. Malloy. Thank you for coming, sir. All right, so that's it for friends or family, Mr. McDaniel. I believe we have Benjamin Maxwell. Mr. Maxwell, good morning. Mr. Maxwell, you're here because you're accused of violating the terms of your state probation. Mr. Maxwell, you were first appeared this weekend. The reason you were brought back today is to get you arraigned on this allegation against you. Arraignment means appointing you a lawyer if you would like one to be appointed. Do you want an attorney appointed to represent you in this VOP, sir?
Yes, sir, I would.
I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel. We'll see if you have any questions in just a moment.
Your Honor, we're going to enter a plea of not guilty. Has to set this in the March 5th pretrial docket, and I advise him that it'll be attorney from the public defender's office will come by and visit him prior to that hearing.
Thank you. Mr. Mitchell, anything?
No, Your Honor.
So as Mr. McDaniel said, an attorney will see you at the jail before your court date. Do you have any questions, Mr. Maxwell?
No, sir.
Have a good day, sir. Mr. McDaniel, we do have one more case. He's not on the list. I think the jail may have.
It's Farnell. It's Terrence Farnell.
Yeah, it's not. He missed the list somehow, but this is State versus Terrence Farnell. I'm sorry, Mr. Farnell. Mr. McDaniel sent us an email this morning where he had already looked at the status. Was it Polk County?
Yeah, Polk County.
From Polk County. So listen to Mr. McDaniel, and we'll listen to Mr. Mitchell. Then we'll see where we go. Mr. McDaniel, anything?
Maybe we go ahead and listen to Mr. Mitchell first, since he was going to talk to him in Polk County Friday.
Yes, Your Honor. I did send an email to the prosecutors down in Polk County, and they acknowledged back that they were going through the motions of revoking his bond, but they have not officially done that yet, or they have not set a hearing like what Mr. McDaniel said at the same time also. So his bond has not been revoked. I have no idea if they're going to or not. So we're not objecting to go ahead and set his bond in this case.
Mr. McDaniel, when I looked at the file after your email, thank you, Mr. Mitchell, it looked to me like all they did was they filed a notice of violation of his pretrial conditions, but they not actually they never asked the judge to revoke his bond. They just basically filed a notice. And if it's like our system up here, the judge doesn't even get it. Judge can't get every notice that's filed in every case. There's no way. It's got to be set for a hearing for the judge to even know it's been filed. So unless there's something I don't know, I don't see where they've even asked the judge to revoke his bond. Am I missing something, Mr. McDaniel?
I want to say at the back of that page, it said notice went to the judge, but I ain't gonna swear to it. But I think in most instances, especially in South Florida, they, basically to hold them without bond, most of the time they can revoke them, but then they got to reset another bond unless they can make a proven that there's no condition that he can stay out of, that he will not show up at a court hearing for. So I think that's always an issue, especially with our South Florida cases, because it's just the way they do things. I can't help but think that's probably in the back of their mind there.
Mr. Farnell, the bottom line is they've had actually a couple of months to do something and they haven't. I think Mr. McDaniel's assessment last week was accurate. And I don't see that there's certainly not any significant effort that I see in that court file where they've asked. In November, they notified the judge of your arrest, but that's all it does. Judge, to make you aware he may have violated a condition of his release. They don't say, Judge, we're asking you to, they don't ask him to do anything. They just make him aware of it. And the judge may have got that, may not have, but it doesn't matter as far as I'm concerned. They've had months to do this and they haven't done it. So I'm going to release that hold from Polk County that I placed on you last week. You're free to post the bond in Jackson County. Now, this doesn't mean they can't revoke your bond in Polk County. What it means is they haven't done it yet. So for all I know, they may do something next week on it, But as far as we go in Jackson County, I'm going to release that hold. You're free to post the bond that was set for you last week. You'll get a chance to use the phone after first appearance today, because anytime your bond status changes, you have the right to notify friends and family or a bondsman for purposes of posting a bond, and you'll get a chance to use the phone shortly. Did we already give him a court date when he was here last week?
We did, it was March 2nd, and I was also going to remind him that he has that hearing in Polk County, because they've had hearings since, they filed that motion also. They got another hearing February 20th, so you got to be in Polk County February 20th for that hearing.
Yes, sir.
So,
Any questions, sir?
No, sir.
All right, wish you the best. We'll see you here March 2nd.
Thank you.
all right.
Mr. McDaniel, it's everything I had on my list. Anything else from the public defender's office?
Nothing else, Your Honor.
All right, friends, once again, good morning. Happy Monday to TCF Live. Good to have you here with us today. Let's go to Texas. Judge Stevens, say good morning.
That enhancement in that way is important for those conversations.
I disagree, Judge. The defendant has been on notice about the offense since its beginning. His prior lawyer was notified at the multiple trial settings that we had about this the prior, and it's been a part of discovery since the beginning. The actual formal notice saying I'm going to use it to enhance was filed today, but the actual knowledge about the prior and what the consequences for it has been in existence since the beginning of this lawyer's representation of this defendant, and well into when this defendant was charged for the offense and when it was initially placed on the trial docket. It's a federal prior. He was sentenced to 36 months, and as I said, all the documentation and all that's part of the discovery and has been for quite some time.
And Judge, if I may, I do have the documentation of it. However, without the formal notice of an enhancement, my assumption is that it's for his ineligibility to receive probation from a jury, not that it's being used for the purpose of enhancement. So I'm not put on notice about that purpose of enhancement or that it's being used for that reason until I'm given that formal notice. It wasn't alleged in the indictment, and I didn't receive that formal notice until this morning.
Give me something that shows that. I mean, you know,
If that's going to delay,
it can be the way they are, but you knew he knows, his previous lawyer has known this has been around, by the way, since over 3 years. And so according to the state, his previous lawyer knew that there was an intent to make it some kind of issue at trial, and then I'm sure that information should have been passed on, but the defendant knew. I can't believe his lawyer would have ignored that and said and refused to inform him. But the question becomes: does a formal piece of paper have to be filed, notwithstanding the knowledge of the parties that there is a prior conviction that can be used, and that the state has tendered to lawyers representing him. And I think you're the third one.
No,
she's the
I'm the
second
second judge. And I believe I've been on it since October of last year.
Because
and I believe I stood here on the record and made a statement about this notice previously. Not, in all fairness, she wasn't there, but Mr. Cobb was.
Was the defendant present as well?
Yes. And the record should state that if it ever becomes an issue.
It may need to be. You may need to find something. We may need to pour into the record. We have the dates that these court settings were made. So that's the issue that this court's concerned about. Doesn't a piece of writing have to be in there when it was stated in the record? with all parties present, because it's all about supplies. And depending upon how it was presented, I mean, I guess, I don't think they just say, and he's got a prior conviction without saying, I intend to use that.
Sure, Judge, but it's about the intention of how it's gonna be used.
No, it's,
One of,
yeah, but if it's going to be used, you have to be, it can be used for all purposes under law. But just find something that says you have to have a formal written motion before that can be used. You just never come up
The only case law I'm aware of is that it has to be done prior to the commencement of trial, Judge. And we've done that satisfactorily today.
Sometimes that puts a defense attorney in a bad spot. Okay. Because what this jumps up from in this case, of course, is from 2 to 20, it's a life. That's
and I understand that Mr. Cloudman had received notice, but in order for me to protect myself, for me to choose to, these are objections that I have to lodge.
okay. But all of that, I know that. But according to what he's stating, the defendant was present, the defendant knows. And whatever the previous attorneys' actions were, they should have been passed on to you.
And I believe
one way or the other, but the defendant knows it.
I believe I have emails with the prior counsel with the intention as well, Judge.
I think you need to get what you can.
Yes, sir.
On that.
Yes, sir.
Please. In fact, I even say there's a motion to withdraw that I even denied
Yes, I think that was around
because of this.
Judge Reagan found these two. I don't want to lose it. It's the notice acknowledgement form and the jury.
But it's there's no way that it can be almost 1,200 days old and still people are declaring surprise. I know there may not have been a formal action taken, but get what you can of supplemental information, so I can make the record, but it's old and needs to be all.
Stated ready.
I hear you.
Oh, thank you.
Thank you.
Potential spam, thank you for becoming a channel member. I really appreciate that. You get to join us on the pre-show now every morning, 30 minutes prior to this show. You get early access to the videos that we post. You get a discount in our store, all sorts of fun stuff. So thanks so much and welcome officially to the best community in LawTube. And I don't say that just because it's the one I run. There's good people here. So, well, I got you. Join us tonight for In the Blind with Mike and Dan. It's a different channel. It is myself, producer Beth, and Michael Groff, who is the official TCF weatherman and guest host for this show and sidebar panelist rather. Probably could be a sidebar topic and all those things. Join us there tonight, though. It's a lot of fun. We have no idea what we're going to talk about until we're live, and Beth tells us what we're going to talk about. So it's raw, it's off the cuff, and it's a good time. Especially segment 3 for the true false round. That's worth watching in and of itself. So 7 p.m. Eastern, excuse me. 7 p.m. Eastern, 4 Pacific. There's a link in the pinned chat, so please check that out tonight.
For alcohol.
You are for or against it?
I'm kind of like straddle like
Okay. There's something about it that's not being, it is not working correctly.
We've had a long history of problems with the ankle monitor. As a matter of fact, we've had numerous hearings in front of this court. So in an abundance of caution, we knock down drag out lights. My client has now had 2 monitors just as a backup because of the unreliability of the ankle.
What's unreliable with that?
Well,
But like I forgot what we talked about before.
Yeah, they're given, our position was given false positives and bringing back, but it's causing a medical problem now. And so I was requesting that.
What's your alternative plan?
Take that off and let him, he has a handheld time that he has to, so how often?
4 times a day.
4 times a day. And he's been on a monitor for how many months now? No.
What's the whole, the whole purpose of it is what? What was the whole purpose?
The whole purpose of one was based on the charge that he doesn't do it. He's been complying with it, but the one that's on his ankle is causing a medical condition now, and he can show the court.
And that just tests for alcohol in the system.
That's all he really puts.
We don't have one to show where he is, like a GPS, like he's
Never
driving around when he
Never
could be.
Never have.
Okay, something though, we don't, neither of us want to be on the front page with this headline, who's to blame if he's out there driving.
That's never been an issue.
Intoxicated. It never is until it becomes. And then everybody points to everybody. And here it is, we're talking about intoxication manslaughter. Shame on what happens next. If something bad happens, there will be an accounting, a rendering. Somebody will be blamed, or 2 or 3. It's not going to be me. So what do we come up with?
Well,
Other than just his good word.
I'm not asking for no monitor. What I'm asking for is because he has another monitor that has been following him for the last 6 months with not any, as a matter of fact, it's a more detailed monitor with no violations.
I just don't understand what the difference is between those two.
Well, it's causing a medical, it's.
I mean, but what does it provide to the people who are
Instead of going out 2 digits. And
supervision?
Well,
So it needs to be supervised, that's all.
Does that one have a camera on it to know that it's him testing?
Yes, ma'am.
So how does the other one that you're talking about, how does that work?
The one that I went out and got on my own tests out 3 decimal places and has a camera showing me using it. The ankle monitor does not.
Well, it's connected to your ankle. So who is monitoring that then?
Johnny's.
Who has been used forever.
Yeah, but the one on the ankle is causing infection. Medically now.
Well, have you gotten to a doctor or something about, I think they can put something can't they put something between the skin and the device? No?
No, because then you don't get the sweat or the.
Well, so can y'all try to work that out, or if there's something that
I
y'all
can
can
show you
reach?
if you want to see his.
No, I'm talking about working it out.
Oh, Judge, I don't have any objections to doing it the other way. I can see what he's talking about. As long as
point,
yes.
Go ahead.
And so.
But it needs to
The
get done.
order is that we will get his documents to you to switch, remove that
All right.
and keep them on.
Okay. What are you doing about preventing an infection?
There's no
Yeah, have you seen the
product
doctor?
that I know. This monitor, sir, this monitors external things, and there's nothing topical I know of that I can use.
Well, if you talk, I know you know, but what does your doctor know? Yeah,
I have not talked to a physician
Be
about it, but
careful
I
about
talked
an
to the
infection.
monitoring service.
Yeah, be careful about that. Especially there. I mean, feet come in handy
Yes, sir.
in life. Okay. All right, well, yeah, request is granted.
Thank you. I'll submit an order today.
Okay, that's done. What's next? Y'all ready for trial otherwise?
We are, but
What's they say?
I think the state would like a special setting because of the circumstances.
Because of the circumstances and having to communicate with this family and the death of their loved one.
Why don't you? why don't y'all get together this morning and give me a date for Tuesday?
Yes,
And
sir.
then that will be set this morning,
Yes,
okay?
Thank you, Your Honor.
Before y'all leave, thank you. Bruce Calhoun,
He's here, Your Honor.
that's nice. What are we gonna do about that?
Look,
What are we doing?
I made it.
It's a 1,000 days old.
Of the state's offers. I just want to I just put on record, Judge, the stated offense, 2 years deferred adjudication probation.
How much?
10 years deferred. 10 deferred.
Which, as we all know, can be shortened to 1/3 of that if they do well.
And I conveyed that to Mr. Calhoun, and what was your response?
What did you say? I didn't understand. Oh, okay. Well, we're gonna go over time. Let's see. That'll be, y'all ready?
We can be ready.
Yeah.
It was tonight.
Also, we've got another court that we're gonna send to. We can send somebody on bond, so that's good. I can get 2 done.
I think everybody on this docket is on bond, Your Honor.
Good. Yeah. That's, okay, y'all stand by. I'm gonna name him in a second. Dagan Rutz?
He's here too. Come on.
Down with that. What are we doing on this? Are you kidding? We're trying this one too?
We're ready, Judge.
Okay.
Give this to Mike, please. Shouldn't put that. Those are the plea rejection forms to kind of, yeah.
Absolutely.
Okay.
You tell, I mean, you did.
What was the offer on this?
Right, like, this is another case where the state had offered deferred adjudication. And did you want the deferred or you still want trial?
Okay. You understand if you happen to be convicted of this in a jury trial, deferred or unadjudicated probation is not something a jury is allowed to give. In a jury trial, you get convicted and the conviction is forever. Okay. You haven't by any chance had contact with the victim in this, right?
No.
Because that would be catastrophe for anybody.
No, sir, just an individual that I did the purchase through on the side by side, that I have to.
Okay.
2 cases of the messengers, so he's actually doing time with it right now. They did it, from Jasper.
Okay. Okay, yeah, all right, and we're gonna try to find you a trial. Alicia Jones. Alicia Jones, Dustin? So,
Yeah, today.
Donald Kelly.
Your Honor. Right.
Well, who's the lawyer on this one?
I think it's,
Miss Moore?
it's Miss Moore, yeah. You'll see.
What? We've never tried a failure to register in 20 years. So
We tried one.
what's the deal on this?
Yeah, I've tried one before. I've actually tried 2 of these. It's just-
How did that other one end up? I think it was a conviction, wasn't it?
Yeah.
Yeah, I do remember now. It was like maybe a year or 2 ago.
Yeah.
But it's very odd.
Yeah.
What's, okay.
Yeah.
Trying to tell you to register. Okay. These are real simple. These are real simplified. Is he eligible for probation?
No, because of the offense.
Prior conviction? Okay, he knows that.
Yes, sir.
All right. No,
I wouldn't
you
say anything.
don't need to talk about it. It's going to move forward and it'll go somewhere today. Willie Dumas?
Ready, Your Honor.
Complete.
We have to bring it down.
Willie Dumas, where are you?
I'm here, sir.
Well, you're loaded today with all kind of hardware.
Oh.
What is all that? What's that on your lapel?
Oh, is it?
Or no, the lapel. There you go.
Oh,
That
here?
one, yes, sir. What is that?
It's a flower with diamonds around it.
What is it, what does it represent?
Oh, no,
A flower with
just
diamonds.
like, coat up.
Oh, well, that's a nice thing. So it certainly got my attention, I'll tell you.
Well,
he does a lot of his
church.
Sir?
He does
Is
a
it
lot
for
of
the
church.
church? Yeah. Okay. That's it. For Willie Dumas Senior, correct, sir?
Yes, sir.
And you were here with Mr. Lang, your attorney, and the state's attorney. Does the defendant waive the formal reading of the indictment and arraignment here? Can we proceed in summary?
He does, Your Honor.
Looks like we're only going on paragraph 1 here, because there's a prior conviction that is not being asserted in this case, at this time. In summary, and you were Willie Eugene Dumas Senior.
Yes, sir.
And Mr. Dumas, this indictment states in summary that on or about December 2nd, 2023, in Jefferson County, Texas, you committed the third-degree felony of theft from an elderly individual. It's like a purse. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for up to 10 years, fined $500. Is there any restitution here?
No, Your
No.
Honor.
Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or
Guilty,
not
sir.
guilty? Are you pleading guilty voluntarily?
Yes, sir.
That is on your own free will.
Yes, sir.
And because you are guilty of this.
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered?
No objection.
Without objection admitted. Will state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. And you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true. The state so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Is a pre-sentence report waived here?
It is by the finish.
Anything to add by either party?
Nothing.
I will follow this agreement and make the findings that you are pleading guilty voluntarily. You are mentally competent to do so. You do appreciate the consequences of pleading guilty. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of theft from elderly person. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That will be suspended. You're going to be placed on regular probation for 10 years. To do well, it will be shortened over.
No problem. Yes, sir.
There will be other terms and conditions of probation, which are normal and customary for this type of offense. There'll be a fine of $500 also imposed here. And among other conditions of probation, you must successfully complete a theft prevention program. It's a good program for everybody. But it's normal and customary for this type of offense. Here are the papers. Please see the probation office and you begin. Good luck. Yes, sir.
Ellie has apparently decided I need a break from pinning me down. Let's Ohio, Judge Cole.
And we're present in case 24 CR 470, State of Ohio versus Stephanie Tellahan. We are here on a motion to terminate community control sanctions scheduled for a final hearing. Defendants here in court with counsel Mr. John Fatika. Mr. Fatika, what's the defendant's intention at this time regarding the final hearing?
Good morning, Your Honor. I've discussed this matter with Ms. Tellahan. I believe she wants to waive the final hearing, accept responsibility for her misconduct, and resolve the violations today.
Thank you. Ms. Tellahan, you're charged with violating the conditions of your community control sanctions. Specifically, it's alleged you violated two separate rules. First, Rule 3, which requires you to report at such times and places as directed by your probation officer. And you were instructed to report to your probation officer on December 17th, 2025, and provide a urine screen, and you failed to do that. And then you made no attempt at all to contact your probation officer since December 17th at that time. Further alleged you violated Rule 10, which requires you to submit urine screens when directed to by your probation officer. It's alleged on January 9th, right when you were arrested or shortly thereafter, you were given two opportunities to provide valid urine screens and you failed to do so. Now you have the right to have a final hearing regarding these allegations, which is a hearing where the state would be required to prove the actual merits of what they're alleging. You could have this final hearing, but you can also waive the hearing if you desire and admit to the violations. And your attorney has indicated he believes that's what you want to do, waive the hearings and admit to the violations. Is that correct?
Yes, Your Honor.
Well, before I can accept your waiver and your admission, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If in fact that did occur, the court could extend your probation up to 5 years. I can impose more restrictive sanctions against you, including an order that you serve more time in our Lake County jail, or I could terminate your probation and send you to prison. If I sent you to prison, it could be 9, 12, 18, 24, 30, or 36 months in prison. Do you understand potential penalties you face if you're found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive the hearing and plead guilty to the two violations?
I'll plead guilty to the two violations.
Very well, then, as the allegation you violated Rule 3 by not reporting to your probation officer when directed to do so. What is your plea to that?
Guilty, right? Guilty.
As the allegation that you did not provide urine samples as directed to do on January 9th, what is your plea to that?
Guilty, Your Honor.
The court will accept your plea of guilty, find that you did violate your community control sanctions. Mr. Fatika, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, thank you, Your Honor. I'd like to highlight the fact that while acknowledging that Ms. Talaha relapsed here, she did have a fairly lengthy period of sobriety. She did complete the program at Nora in recovery, and she also turned herself in after going to Nora. She was initially put on probation, in this case on April 7th of 2024. We'd ask you to take all those factors into consideration here in rendering a decision on these violations. I'd also would ask that Mr. Heller from Nora, who's here, be permitted to speak on her behalf.
Sure. Whoever would like to speak, you can just stand right where you're sitting. State your name and spell your last name for the court report and tell me whatever you'd like me to know.
Larry Heller, Heller, with Nora. And we understand that a relapse did occur here. A relapse is not uncommon, as this court probably knows. National Institutes of Health and National Institute on Drug Abuse have created the principles of effective treatment, which includes that multiple attempts at treatment are often necessary. Recovery is often not a straight line. Most people are not perfect. Many people do require multiple attempts. Some may have multiple attempts where they get almost no traction and no benefit before they finally engage. Some, as the case here, there are starts and stops and periods of recovery with setbacks, often 3 steps forward and 2 steps back, as I believe is the case here. As Mr. Fatigue said, Ms. Talaha has made substantial progress. A couple of years ago, when her case began, she would have struggled greatly to put together 24 hours without using it, without reoffending. Yet recently, she's put together a consecutive string of several months without using and without reoffending. That's a miraculous achievement. I believe the reason she's in the court, of course, is because of the 2 steps back, but I think it's imperative that we also look at the big picture and take into account the 3 steps forward. We realized there were some setbacks. I realized there were some either refusal to test, there may have been some positive tests prior to that, but we know she was in a period of relapse. She did willingly come back to Nora on her own. Okay, so that says a lot. I understand I have not seen her actual test results, but I did confirm with our nurse that although she did test positive, that levels were declining throughout the week or so that she was with us before her arrest. So even though test results may have been considered positive, which may be what scared her from doing this, I don't know that, but even though test results would show as positive, the levels were declining, which indicates no continuing use. As I'm sure this court knows, some substances can remain in the system for an extended period of time, but as long as levels are declining, that indicates there's no new usage. So I hope the court will consider all this progress she has made. We understand there may have been some poor decisions. That's not uncommon. During a period of relapse and following a period of relapse, there are often poor decisions. We use cognitive behavioral therapy, which is the standard of care. We help clients to identify and explore their own thinking errors and help to improve decision making. That's part of what treatment involves. But we do understand that early in treatment or following a period of relapse, there are some poor decisions. So in summary, we hope this court will consider the tremendous progress that's been made, look at the big picture and take into account the 3 steps forward rather than just the 2 steps back which brought her here. Thank you.
Thank you. Ms. Talaha, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor. I want to apologize for my behavior. I did relapse, and I was just scared. I was doing really good. I had 14 months clean, and I like the structure being in the treatment facility. I did gain a lot of sober support there. I met a lot of good people there. But I am very sorry for my behavior. I hold myself accountable. I did relapse. I was doing really good. Like I said, I had 14 months clean, and I would like to return back there. And Yeah, I'm sorry, Your Honor.
Thank you. Mr. Patik, anything else on behalf of the defense?
No, thank you, Your Honor.
Well, I've reviewed the original pre-sentence report and investigation. Consider the facts and circumstances of the underlying offense, the nature of the offense, and performance on probation. I've considered everything said here today by Mr. Fatika, the defendant, Mr. Heller. All this is considered by the court in light of purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, I'm going to incorporate all the findings I made at the original sentencing regarding the seriousness factors and the recidivism factors, with the additional finding today that the defendant has again failed to comply with the previously imposed sanctions ordered by a court, which is a factor indicating recidivism is likely, more likely. The problem here, Ms. Talaha, is that when you were sentenced last time, it was made very, very clear to you you're getting one chance. With your history, you were lucky you got one chance. You've got a horrible history, a criminal record that goes back, where are we at now? 30 years, counting juvenile court. And if we're going to look at the big picture, let's look at the big picture. There have been multiple attempts for treatment. There have been multiple steps backwards. This isn't the first 2 steps backwards. It's been going on for years and years and years. But the biggest thing to the court is the nature of the offense itself. This offense involves someone dying because of drug overdose, which you were a part of. It's not just a possession charge. It's a possession charge is a completely different story. You were involved in someone dying, and you had involvement with that, and your conduct contributed to that. And despite that, you got probation. And you got probation with this history of 30 years of drug usage and treatment and probation violation after probation violation after probation violation. You've been involved in every treatment program there is around here almost. And you couldn't get to the end of the year. So I'm not going to ignore the nature of this offense. I ignored it last time when we were here. Someone died, and you choose to get back into the same stuff. When someone died as a result of something you did. You contributed to it. And you were given probation for that with your history. And again, you went about 7 months before you violated. Therefore, the court finds at this time that prison is consistent with the purposes and principles of sentencing. It always has been with this offense, and that you're not amenable to available community control sanctions. Therefore, it would be the sentence to this court. How much credit is there? 220, is there, or 222?
I believe it's 220.
Sorry?
220.
All right. It'd be a sentence to this court that the defendant serve a term in prison of 30 months. She has credit for 220 days. Need to advise you upon your release from prison, you'll be placed, or you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can send you back to prison as punishment for violating the rules for another 9 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence here today. Defendant's ordered to pay all costs, and the court disapproves the defendant's placement in a program for transitional shock release, intentional prison program, or transfer to transitional control. Mr. Fatika, anything else for the record?
No, thank you, Your Honor.
All right.
Well, there you have it, folks. I agree with Lindsay in the chat. She says that, she needs structure. Jail will be structured. I would tend to agree with that. Happy Monday to you once again. Once again? once again. There we go. It's TCF Live. It's episode 227, and in the previous 226, I never apparently learned how to speak properly, so it carries over to 227. Oh heavens. Let's go to Texas. Judge West, say good morning to her.
John Martin.
Yes, ma'am.
And Mr. Martin is charged with injury to a child, elderly, or disabled individual and clause number 25 DCCR 0583. What is the announcement?
We were waiting for CPS records. I understand that the records were just delivered, but they have not been reviewed.
I was able to download them last week, Judge, that I got with Miss Addings from CPS Family Services. They had previously sent them to our old email handle for the county, and so they thought they had provided them, but they hadn't.
Usually I thought they sent those to
I
us.
usually thought they did send them to you. They gave me the originals and the redacted. I did not turn them over yet because I wanted to see the guidance on that. I have them all downloaded, but
They've always sent them to us, and then we give you the redacted, and I keep the original.
Right.
So I would ask if you would maybe forward all that.
To you.
Forward the redacted to Mr. Burbank. You keep a redacted, send me the original, and if you'll send her maybe a return email that just asks why they did it that way, because typically it comes to the court, so we have y'all sign off that you received it. But I'll just do a normal reset. Sounds like you'll get it later date probably, and then go call Mr. Burbank. Y'all visit before that next court date, and we'll get an announcement the next.
I haven't opened the originals, Judge, other than to check the page number. to
Yeah.
make sure they were-
No, if you'll just send the original to me, I think, and I keep that, and then you guys both keep a redacted version.
Okay.
Okay, thank you.
I have the excuse.
Yes, sir. Thank you. Ms. DeLage, you've got Carly Davis.
Yes, sir. Yes, we do.
Good morning.
Good morning. How are you?
Good. How about you?
Good. Sorry, I was in the other court the other.
Nope, you're good. Good morning. Are you Carly Davis? Speak up.
Yes, ma'am.
And Ms. Davis has two cases, 25 DCCR 1451 and 1452, both driving while intoxicated, third or more. And what is the announcement?
Judge, we're gonna ask for a trial setting.
All right, did you already do a plea bargain rejection?
I thought there was there one before I came on? No.
I don't see one in this case at least. So I would ask that you do one with her this morning. As soon as you do that, I'll go through everything and then we'll get it set.
Okay, sounds good.
Okay, thanks. And then, Ms. DeLage, real quick, before you do that, you've got Christopher Pickens,
Yes,
two
ma'am.
cases, Christopher Pickens. Good morning, you're Christopher Pickens?
Yes, ma'am.
And Mr. Pickens has two cases, clause numbers 24 DCCR 2275 and 24 DCCR 2276. Both cases are injury to a child, elderly, or disabled individual set for trial to begin with jury selection on the 23rd. And what is the announcement?
Judge, in this case, it looks like the mother with the children had moved out of state. They are not cooperating. The sister has quit answering their phone calls. If we can reset this to a status hearing and I'll issue a subpoena, I suspect we'll probably wind up having to dismiss it that.
How long do you need? Just 30 days? So what we'll do is just reset this to just kind of a status to give the state time to send it subpoenas. If somebody shows up, we'll see what happens. If not, then it'll get taken care of on that day.
Thank you.
So make sure you're back on that day and we'll see what happens, okay?
Yes, ma'am.
All right, thank you.
Thank you.
See Mr. Galmore. Mr. Gertz, you have Jose Colazzo. That's Miss Malfino.
She just ran upstairs.
Let me just hold that for just a minute.
And
You've got Jaren Crane. Oh, that's also with her.
yeah, and we're doing a plea on Mr. Crane.
Okay,
We're just announcing ready for trial. Also, but
hold on. I'm holding Crane for a plea. We'll get Mr. Colazzo up here in just a minute when Miss Malfino's back. What about Bruce Hill?
Judge, I'm gonna ask for a little more time. That's with Ms. Malfino
Let's
as well.
wait for her to come
But I'm
back.
gonna
Yeah.
ask for a little more time on Mr. Hill because we're negotiating, but we don't have it done yet.
All right, I'll call it when she gets back down. Mr. Lewis? You've got Justin Wallace. Morning. You were stuck over on the side. I didn't see you. Good morning, sir. You're Justin Wallace. This is 24 DCCR 1590, and Mr. Wallace's case is set for trial on for the 23rd. And what is the announcement?
Ready to. State's ready for trial.
All right, then what'll happen is
I'm
I
sorry,
will.
sorry to interrupt. I think
Yeah.
there may be something that we need to address. Is this the one where I did the habitual, or am I thinking of another case?
No, you did it on this one.
I did on this
Yeah,
one.
the no.
Notice of intent.
Well, yes, Judge. I found a 1997 federal conviction for possession of controlled substance, and I've added that to the previous felony conviction this defendant has from 2006, felony possession of a controlled substance case. I believe it makes him subject to being a habitual offender, and I filed a notice, Judge.
So it looks like when we did the initial plea bargain rejection, that Mr. Wallace was admonished with regard to first-degree felony punishment. Have you discussed with him the new possible consequences based on those convictions?
I have, Judge. I've got him. He's come to the office. We discussed that last week after my talks with Mr. Cole.
So I just want to make sure you understand, Mr. Wallace, before I number the cases for trial for the 23rd, that if you go to trial and you're found guilty and those prior convictions are true, that changes your potential punishment to a minimum of 25 years, up to 99 years or life. You understand?
Yes.
And do you want to reject that and move forward with your trial?
Yes, ma'am.
All right, I do want to make sure that you understand that after today, I will not accept plea agreements unless some new information or evidence comes to light that the attorneys did not know for some reason. Other than that, what I'll do is tomorrow after the docket, set the trial order. Mr. Lewis will know and let you know when you need to be back on the 23rd.
Yes, ma'am.
All right, we'll see you then.
Thank you, Judge.
Yes, sir.
Thanks, Judge. Judge.
Yes, sir. Yeah.
All right, friends, let's stay in Texas, but we'll head to San Antonio and continue with our commitment to 9 to 11% more Judge Boyd.
2025 CR 002639, State versus Michael Anthony Foz. Can I have parties announced for the record?
Arlene Gay for the defendant.
Right, and are you Mr. Foz? All right, you entered a plea of true to violations 2 and 4 on February 6th. The court found that there was sufficient evidence to find it true. The court found it true. And so we're here today for witnesses to be presented.
We do have a witness.
All right. And state, do you have any witnesses? All right, defense, you may call your witness.
The defense calls Priscilla Garza. He is in the courtroom. Mr. Fox, put your back against the counter over here.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand if you'll state your name for the record.
Priscilla Garza.
All right, you may proceed.
Ms. Garza, how do you know Michael?
He's my fiance.
And where do you live? Do you live here in San Antonio?
Yes,
And who do you live with?
and I'm going to stay on my mom.
Okay. Who lives with you?
Me, my mom, and my two stepsons.
So you have 2 stepsons?
Yeah.
And do you and Michael have any children together, biological?
No, ma'am.
And just what are their ages?
One's 12 and the other one's 8.
And you are the kids were staying with you. Was that due to Michael not being able to live in the home with you and the children?
Yes, ma'am.
And
He wasn't able to stay there.
And is it your understanding that that was a court order when he was sentenced? And you are caring for his children? And do you plan to get married? Do you have a date or?
No, right now I just got the paper for him to sign because he's not able to be there, not be an absent, not be.
Like a marriage by proxy, or is that what you're talking about? Like getting married without him being present?
Well, if it's possible, yeah.
Yeah, just in case whatever the court rules today?
Yes, ma'am.
Okay. And are you asking the judge to continue him on his deferred?
Yes, actually, I am.
Okay. And was he a good provider to you and his children?
Yes, he was.
And
What, he's the only provider. Just, I gotta stay at home and I make sure the kids are okay, so they go to school. He's the only one.
And is there anything else that you want the judge to know that you've not already told them?
Just I know that his boy's missing and they want him home.
And his children are present, but not in the courtroom. Is that correct? I'll pass the witness.
Ma'am, I'm sorry, I didn't catch your name. What was that?
Priscilla Garza.
Priscilla Garza. Okay, and so how long have you been in a relationship with the defendant?
9 years.
9 years?
Yes, ma'am.
So you all were in a relationship with each other when this actual deadly weapon occurred?
Yes.
Okay. And so then you all were also in a relationship when he was placed on probation in April of 2025, is that correct?
Yes, ma'am.
Okay. And when he was granted probation, originally, were you aware that he had a condition of an electronic leg monitoring device?
When he was staying at his grandparents, yes.
Okay. And then at some point that GPS device was removed. Are you aware of that?
Yes, his probation officer asked for it to be removed.
Okay. And then after it was removed, were you aware that the probation department never heard from him again? Okay. Was he living with you?
No, he wasn't allowed to stay with me and the boys.
Okay. So where was he living?
What the address at 318 Los Angeles.
Okay. And who else lives at 318 Los Angeles?
His grandfather and his uncle.
And were you aware that the probation office made multiple field visits to that location? And the people that lived there said that the defendant was no longer living there?
I'm going to object to hearsay.
Right, that'll be sustained.
Okay. Were you aware that the probation office made multiple field visits to that location?
Your Honor, the fact's not in evidence at this time.
All right, that'll
We're
be
going to
over.
object and also
That'll be-
the hearsay.
That will be overruled.
Were you aware that the probation office made multiple field visits to that location?
No.
And were you aware that the probation office was unable to contact them there at that location?
Well, I
Same
know he
objection.
was.
Also,
Right, that'll be overruled.
Well, I know most of the time when they did go, he was at work. Because he did work, because that was one of his conditions on his probation.
Where was he working?
He was working for a painting company.
Okay. And so I guess you were unable to have contact with him as a condition of probation, or just?
He would just call and he'll visit the boys, but I know he was supposed to be under supervision to visit the boys, but he never, sometimes he did, but I was there, but sometimes he didn't, because he always worked. He, like I said, he's the main provider for me and his boys. So
And
he's always working.
so correct me if I'm wrong, but the children, they're his biological children, but you're just taking care of them, right?
Yes.
Okay. And you said that he's the only provider, so you don't have anything.
I don't have employment.
Okay. And so if you're asking this court for him to stay on, and he has not been reporting, like, what facts are you relying on to ask the court to continue with him?
Well, the fact is, y'all are asking him to work. So if he's supposed to work and he's not supposed to be there at the house when they go do a field visit or whatever, how is that supposed to even be possible? Because sometimes they do pop-ups and he's at work.
Okay, well, that's why there are multiple conditions in place. So are you aware that he was also supposed to report to the probation office?
And he would.
And a violation that he's pled true to is that he was not reporting.
Before, when he first got on it, he was reporting.
When
After
he
that,
had the ankle monitor on, correct?
no.
Yes. And once the ankle monitor was removed, he pled true to not reporting to probation.
Okay, well, I'm not aware of that because he wasn't staying with me.
Okay, and so you're asking this court, even though you have no facts in how he's performed on probation, you're coming up here and asking this court to continue.
Or he does have two kids that he needs to help me take care of. There's two boys. You try raising two boys on your own. When I'm not the biological mom, I'm the stepmom.
All right. Don't you think the appropriate time for him to think of his two children was when he was stabbing someone, not when he's on probation?
Can I please leave?
No, no, dear, you cannot. Your Honor, I believe that that's a harassing question.
Is there a legal objection?
And yes, Your Honor, that it's not relevant or material, and it is harassing
With
the
regards
witness.
to relevancy, the court will sustain the objection.
That's the witness, yeah.
All right, any further questions?
No further
All right,
questions.
thank you so much for coming in. Call your next witness.
I'll call my client.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Absolutely.
All right, you can lower your hand if you'll state your name for the record.
Michael Anthony Foss.
All right, defense, you may proceed.
Mr. Foz, before you were putting Dawn deferred, you got custody of your children, correct?
Long before,
About a year before,
way more.
2 years before? Yes.
Yes, ma'am.
Okay. So, your mother of your children had custody, and then CPS got involved, and then you,
Sustained.
so, tell me how you got custody of your children.
I got custody of my children, fighting for them for more than about 8 months. While I was doing federal probation, federal classes, at the same time doing state classes and state UAs, I believe is what they said. And they were coexisting with my federal PO at the same time. And I found, and then the judge who, I believe, I don't know the proper name, for the kids, I guess for CPS, that judge at that time in CPS, the state found fit after all my certificates while I was wrestling with federal probations and state agencies at the same time, while working a full-time job, supporting my kids. That they found that I was fit to be the father, and they found fit to terminate the rights of their biological mother.
And, so you have custody, you have your fiance, and, how many households were you supporting after you got on this deferred in April of 2025?
Okay, when I moved in with my grandparents and my uncle, my grandfather's house, I'm sorry, my grandmother passed away. When I moved there, of course, I'm not gonna take advantage of my family, so I'm paying rent there, about $450, $500 a month. I'm still supporting my kids because that was one of the stipulations, support to dependents. So I'm paying about $300, $400 there for them. Then I'm paying my cell phone bill. Then I'm paying UAs when I go take the test. I gotta pay for the parenting class, $85 off the rip. I did 5 out of 10 classes, hostility classes. The only reason I didn't do the other 5, man, I really tried to knock it out. And I realized that we couldn't do the other 5 is because the other 5, they wanted to do them as a one-on-one, I believe it was. And he said he was gonna call me. But I told him I had to go to work because all these places, and that's not including my food that I was eating on the day.
Right, so here's the thing. The state recommended that you have deferred. What I want to know is you pled true to violation of condition number 2. So I wanted to know why you missed drug testing. You pled true to violation for condition number 4. So I want to know why you missed reporting.
Simple fact, miss. I wasn't paying my restitution. What did it call? Constitute the $4,000 that I had to pay. I was paying. I'm paying $2,000 when I filed my taxes, and I told Mr.
But what does that mean about the not taking UAs? That's what I'm trying to figure out. Why were you not taking your UAs?
When I stopped reporting, ma'am, I didn't go take the UAs run because I was afraid that I was going to get arrested because he was getting on my butt.
Okay, do I not tell everybody if there's an issue with probation? If you have an issue, let probation know about it. And if they're not addressing it, you can come and address it with the court.
See, yes, ma'am. And
So why didn't you do that?
My assuming, it's plain and simple, my stupidity assuming them, I'm not gonna make an excuse. I assume, cause it's never been, this is the only state thing. In federal, when they tell you is, you don't do it, it's bye. No ifs, ands, or buts, man. And I was scared. And I was just literally trying to buy time to pay this whole freak off, that's it. There's the whole thing off. You know what I mean? I was working, and everything, and I did report after the monitor was off. I did do several UAs after the monitor was off.
And so when was the monitor taken off?
Even that gentleman,
No, when was the monitor removed? Does anyone know?
I can tell that, I really don't know, man.
Defense, do you know when the GPS monitor was removed?
I thought it was, it's either August or September.
State, do you know when it was removed? All right, probation, do you?
July 9th.
Okay, July 9th. So when it was removed in July 9th, were there any missed appointments, or is the first missed appointment in October? Does anyone know that?
Did UA in September 2025 and that UA was negative.
The last UA was on 9/19/2025, and it was negative.
So it appears that something happened October and November. So does anyone know what happened with him for October?
Your Honor, I think he was trying to explain that when he would go in, his officer was, according to him, putting pressure on him to pay these fees. And, you know, my client is a very verbal person and, you know, I think there was not a meeting of the minds that this court would never revoke somebody for monies. We don't have debtor's prison. But he was getting pressure that he had to pay this money. And he's supporting 2 households in at this time. And he is working. And I want to talk a little bit about work because he had, when one job would stop, he would get another one in between. He's a painter. So if they didn't have a house to paint, he would go and he worked with another person to be working this entire time to support his children and to support these 2 households. And he does not get subsidy from CPS case. He is the biological dad. He did get custody of his father. And Your Honor, I did go back and look at the sentencing on YouTube, and I couldn't hear everything because I think there was an audio problem. But I think the court had concerns of why he couldn't live with his children. And the concerns were the nature of the offense and the court wanted to make sure he was not gang affiliated. Those were the 2 things that the court expressed, say, hey, but we can change that. And you did say that. And according to my client, he is not gang affiliated. They did the gang referral of the gang process.
So you're telling me with the tattoo that he has on the top of his head, that's not gang related? Nobody loves San Antonio that much. I mean, I think San Antonio is a great place to stay, obviously, because I'm here, but usually those are gang affiliations.
But did you do your gang evaluation?
Yes, I did. Yes, ma'am. You ordered it under custody, as a matter of fact.
He had to, and that was correct. He had to stay in custody to do his TAP evaluation, and they were going to do the gang affiliation or
Gang affiliation completed?
Check it out.
Pleaded on the 15th of May last year, Judge.
And what were the results?
Yeah, they determined there was no affiliation.
That's shocking.
Mhm. And he did whisper to me that he is in, he's, yeah, so he's not with the gang, with any type of gang in the jail.
All right, state, what are you requesting? All right. This is what the court is going to do. I'm going to give you two choices. There are no other choices. These are your only choices. Do you understand? All right. One, I do note that the state was, not this prosecutor, but the previous prosecutor asked for 4 years deferred. So the court placed you on 5 years deferred adjudication based upon my review of everything. So one, I will revoke you, sentence you to 2 years in the prison. Or two, I'll continue you and you're going to be on GPS until further notice, and it'll be GPS for employment only. Which do you prefer?
Can we step back, Your Honor? Yes. Thank you, Your Honor.
All right, well, we'll come back and see what they decide. In the meantime, let's go. Where do we want to go? Stevens, let's go back there.
And Mr. Smith has a new case that's just been indicted. I think it's a week or so. And so this one's time to figure out how to handle both things together, maybe.
Okay, let's see. What we've got here is theft of service, state jail felony. What's new?
Your Honor, he was indicted on a new possession of a controlled substance case. Just possession of a controlled substance case. So Mr. West is asking if he can have some time to work them out
Give
together.
me the indictment, or can you give me any information about this? Thank you.
Here's the indictment on that case.
I need to go over this other case like Mark, he knows about that. It's a different day, a different time. It's still gonna help us in negotiations.
I think I took the deal. Okay.
No, I'm doing myself. You're doing all making impact. I didn't find it in the email.
Good.
I don't want to make the case.
A 20. Okay, now I see what's happening. So he's indicted May of 24 for an offense that allegedly occurred January 27th, 2024. State jail felony of theft. Then apparently he's not arrested for a while.
I think that's true.
Until he gets arrested for the state jail felony of methamphetamine, which occurs on February 12th, 2025 is the allegation of the offense. And that's when he is in, that's the day he finds himself in custody. And he's before a judge the next day on 2/13/25, year ago. And he's given a $6,000 bond for the theft and $10,000 for the possession of drugs. And you also have a drug patch as a condition upon?
No.
You do. I just ordered it. You're gonna have to have a drug patch. You got 24 hours to get one, 48 hours to get one. But why that wasn't done is beyond me. It's done in every drug case, especially methamphetamine. I don't know what the JP was thinking about. It's not a debate.
I should. I was.
And the drug, it's a patch, you check it, shows up positive, you'll sit in jail until we can get this done.
Yeah, I see this.
Reset, no more resets. What are we doing today?
Well, Your Honor, like I said, I was on the trying to go over this new case to figure out what's going on and maybe.
What new case is it?
The drug case just got indicted. I didn't.
Well,
We're set for trial on the theft of service, Your Honor. The new case, I provided an offer to Mr. West to work them both out together. He just hasn't had an opportunity to review discovery.
yeah, but he was.
The state's ready on the theft of service if we need to
A
do that.
year ago, he knew that was, y'all knew that was coming down the pike. He does. Judge DeRuin went methodically and slowly, and he had to post 2 bonds. Well, you had to know that, but all right. That's it.
Thank you.
Is this for me?
That's my copy. I just let you review it.
How do you?
I can print you one.
All right, thanks.
The 26 0129. It might not be. It was just a record.
Yeah, it's just. That's me. No.
You want me to try to find it for you?
No, the indictment's good enough.
That's really all there is.
Yes.
Today, what are you doing today?
I'd ask for a resetting on this.
Why don't y'all go over this before you ask for the resetting?
We're still, we got all, let's go over the discovery and show my client this new case. So we get, I mean, we can even take a short reset, if you want to give us some time, so I can go ahead and discover my client. Yeah, that's fine.
Okay, 2. Okay.
Reset from her and meeting outside.
Reset 2 weeks.
Reset from her.
Thank you.
Give you one available.
Yeah, let's.
All right, let's go back to Judge Boyd's court. It's not the defendant that we left, but she does have a new contestant.
Yeah. Was it that case? Okay. All right. Sure.
Hello. All right. Court is calling 2023 CR 2781 State versus Titus Ramirez. Can I have parties announced?
James Tochi for Mr. Ramirez, Judge.
And are you Mr. Ramirez? All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Titus Ramirez who was placed on deferred adjudication in 2023 CR 2781 for the offense of failure to stop and render aid on August 28, 2023 for a period of 5 years? All right, state, you may proceed.
Number 2, on or about the 25th day of June 2024 in Bear County, Texas. The defendant Titus Jeremy Ramirez did then and there fail to submit to drug testing as directed by the court, supervision officer, and or a duly authorized agent of the court in violation condition number 2.
How do you plead to that? True or not true? How do you plead to that? True or not true?
So it's not true.
Well, the June 2024 date, is that true or not true?
That's true.
Okay.
On or about the 24th day of July 2024 in Bear County, Texas, the defendant Titus Jeremy Ramirez did then and there fail to submit to drug testing as directed by the court/supervision officer or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 2 on or about the 30th day of August 2024 in Rose County, Texas. The defendant Titus Jeremy Ramirez did then and there fail to submit to drug testing as directed by the court supervision officer or a duly authorized agent by the court in violation of condition number 2.
How do you plead to that? True or not true?
It's true.
The state will waive the remaining.
Any objection?
No, ma'am.
The judge stand by pleading true to 2 and 2. The court could find it true, grant the motion, find you guilty, sentence you up to 5 years in the prison and up to a $5,000 fine. Do you understand that?
That's right.
Knowing that, do you still wish to plead true to 2 and 2?
That's right.
Court will find 2 and 2 true. Is there a proposed agreement?
Stated asking that you grant speech motion, enter an adjudication of guilt and sentence to 10 years in prison.
And defense, what are you requesting?
Well, Judge, obviously not that. The recommendation, so the court is aware that is being made by probation is to keep them on probation. They have a slew of treatments that they are recommending to the court. I'd be more in line with that, to include SATF and MRT. Mr. Ramirez, this is not very unique, but he's just one of those guys that, stepped off the line and never, ever found his way back.
So why isn't he taking his drug tests?
I asked him the same thing. What happened? He became homeless. He was checking in for a while. I think he had a good, solid beginning to his probation, and then he became homeless. And
Well, I see that this is the first motion to revoke since he was placed on probation in 2023.
it appears that way. And admittedly, on paper, he does not, look like a great candidate. But being homeless, I can't imagine doing anything in life, especially being on probation. He's more stabilized now. Apparently, his parents have accepted him into his home. He tells me that he has been working for the past 8 months. And I asked him, why didn't you come back after that? And of course, it's the trap they all fall in. Once the warrant goes out, they feel like all hope is lost and it doesn't matter. So they just stay away.
All right, any objection to the court reviewing the court summary?
Okay. He would like treatment. I'll let the court read the summary, but he definitely would be interested in residential treatment. He feels it would help him.
All right, this is what the court is going to do. 1, I can revoke you and I'll sentence you to 4 years, or I'll continue you, but you're going to be in inpatient treatment. Which do you prefer?
Inpatient treatment.
All right, the court will deny the motion. Alternate amending conditions to include SATA and portable alcohol monitoring for 1 year. There's to be no driving. There's to be regular random UAs. Field visits 1 time per month until further notice. Probation, the court is recommending SATF. However, I see that he has a TAP evaluation scheduled for February 12th, 2026. If the TAP evaluation recommends something more intensive, then we'll go with the TAP recommendation.
Yes.
If they're just recommending supportive outpatient treatment, we're going to go with SATA. All right. Is there anything else you need from the court?
No.
Probation, is there anything else that's needed? All right, state your excuse. Thank you. Here's the thing. From here on out, everything you do, you need to ask yourself, could this potentially result in me being in prison for 5 years? If the answer is yes, don't do it. And I'm going to tell you what I tell everybody. If there's an issue, let probation know about it. If you feel they're not addressing it, you can come back to the court. Do you understand?
Yes, I do. Thank you, Your Honor.
All right, good luck to you.
Thank you.
Are the parties ready on Mr. Foz? All right. We're back on the record in 2025 CR 002639. Which do you prefer?
The 2 years.
Okay. So are you waiving your right to appeal?
Yes.
All right, court is going to grant the motion. Revoke. Court is going to sentence you to 2 years in the prison. You get credit for any time served. There's an affirmative finding of deadly weapon. And there's to be no contact with the complainant. Review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney. Did you understand it? All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, sir.
Come on this way.
All right, anyone else ready?
Well, know thyself, I guess. He chose prison. To each their own. Stay in Texas, go back to Judge Stevens.
Two cases for pleading the one, she's dismissing one, he's got 10,860 out of the institution. Is that right? That's 860 to me.
Yes, I believe so.
Okay, we got two cases. He's gonna plead to one and one's gonna be dismissed.
Oh, one, oh, two is getting dismissed.
That's correct, Your Honor.
All right, we talked two cases, 24 CR 1901, 1902, the state of Texas versus Jacob J, middle initial, Houston. That's you with Mr. Kimmer, your attorney and the state's attorney. On 1901, does the defendant waive a formal reading of the indictment and arraignment here? So we proceed in second.
So
In summary, this indictment alleges that on or about August 17th, 2020, and continuing until on or about December 28th, 2020, in Jefferson County, Texas, you committed the state jail felony of theft. Do you understand what you're charged with?
Speaker? Yes, sir.
Dick.
Okay. Yeah. Just straight up. Perfect.
This is a state jail felony, which means if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. And also a fine up to $10,000 can be assessed. Do you understand? An agreement has been reached in your case. You'll be pleading guilty and placed on deferred or unadjudicated probation. This can be up to 5 years in length. There will be terms and conditions of probation, which are normal and customary. The most important thing, there's restitution owed in the amount of $10,869. I think, I can't read that last number. Is that even? Or is there 8 cents or something?
There's no sense.
No sense. Generally, there's never been cents up here. That was kind of a side remark. How are you going to pay this back, sir? A little at a time, I guess.
Yes.
How much are you able to pay back per month? Because that's really the key thing. Once you get it paid back, as long as you're doing fine, I dismiss these cases. I dismiss them. It's dismissed as long as you don't have any other problems.
But
But it needs to get paid back. That's how you fix it. And the quicker you pay back, the quicker the damages.
Like $500 a month.
Can you? All right, well, that's 20 months.
COVID benefits, so they want some time to you know, so they total payments made and the extra reimbursement needs to see.
Yes, it goes to the
Well,
Texas.
they don't
Work
forget you
Commission.
and that they make, something will be taken away from you, you know, by governments when you don't pay if you owe them somehow, the way they do that. So you want to get that done so you can move on with your life. Is that your understanding of the agreement, as well as a second case will be dismissed? If I follow this agreement in each case, you have no right of appeal. Do you understand?
Yes.
How do you plead to this case? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Yes,
Yes.
I show you what's marked to State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct? State's Exhibit 110, without objection, admitted. This states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states at the bottom, so help you God.
Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report is hereby waived.
So,
If nothing further, I will find as follows: you are mentally competent, sir, Mr. Houston, to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt from State's Exhibit 1. But I am instead going to defer and postpone any finding of guilt so long as you follow the terms and conditions of probation, which I have before me. This will be for 5 years and will be shortened if you do well. There will be various terms and conditions of probation, which are normal and customary for this type of offense. Most importantly, restitution is owed to the complainant in the amount of $10,869. It looks like Texas Workforce Commission or the state entity that runs and manages that entity. And that is, as long as you do well otherwise, that's really the thing that's keeping you on probation. And then do well, probation is dismissed. And the case is dismissed without a conviction. Can't be that.
Judge, we'll add a theft prevention program as well.
Yeah, that's normal and customary for everything, for that type of offense.
Yeah, I need to print it.
Please on probation. To do. Thank you.
All right, at the moment in Courtlandia, Texas is the place to be. So let's go back to Judge Boyd.
It's calling 2025 CR 015674, State versus Stephen Yet. Could I have parties announced?
Brandon Prada for the state.
Danielle Cranbrook for the defense, Associate Attorney of Monica Guerrero, the Attorney of Record.
All right. Any objections to proceeding with this attorney, sir? All right. And are you Stephen Yet? How do you pronounce your last name? Okay. Counsel, have you received all discovery?
We have, Your Honor.
Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication and community supervision with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Sir, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1 to 4 grams. All right, let's go off the record. All right, anyone else ready?
Page, 3, third down, Rodriguez.
Enrique Rodriguez. All right, that's Mr. Chumbley.
Oh, yes.
Hi. That's okay. Oh, that's okay. And counsel, you're on this side.
That's right.
Right, so
Okay. I had met with my client last week and we got an offer. There's some discovery that I'd like to verify that I've got everything. There's some videos that are pretty important on the case. I don't need a bunch of time, you know, maybe 3 weeks or 2 weeks, something like that.
all right, Ms. Fergus, can you recall this in 2 weeks, please?
Oh, I would really like to settle this today.
Oh, you'll need to speak to your attorney.
Okay, all right. Well, that's different from last week. So.
Okay.
Okay, all right, thank you.
You're welcome.
So no date right now, just.
No date right now.
Okay.
All right, who's next?
One second, Judge, signing in.
While they rack up another contestant, Barb just asked me in the chat if we're doing a 4th hour today. Yes, we are. I've got a couple of stories to cover. One of them is super interesting. It talks about the role of AI in court proceedings shown on YouTube. So definitely topical to what we face in this community. So I want to go through that. Of course, you can join me in the 4th hour if you're a channel member. The link has been posted over in the Discord. So call in, say hi, and let me know what you think on today's cases or any other topic. But it does look like she's going to take a minute to rack up the next contestant. So let's go back to Judge Stevens.
It's just one case, right?
Yes, Judge.
Yes, sir. You're Mr. Calvin. Does the defendant waive a formal reading of this indictment and arraignment in 22 CR 159? Can we proceed in summary?
Yes, sir.
In summary, Mr. Calhoun, this indictment, as you know, states that on or about May 29th, 2022, in Jefferson County, Texas, it is alleged you committed the 2nd-degree felony of aggravated assault with a deadly weapon, namely a machete. You understand what you're charged with here. Now, this carries with it up to 20 years in prison, normally. The agreement has been reached where you would be pleading guilty to the lesser included Class A misdemeanor of assault, which carries with it up to 1 year in the county jail and or a fine up to $4,000. Is this your understanding of the agreement?
Yes.
You know.
Judge, you have to press the button to erase.
Yeah. You would think that. Agreement has further been reached where you would be sentenced. Don't got it right in English because this scribble is, it looks like 180 days in jail.
Credit time served 180.
That's correct, Judge.
Well, I don't know what the credit is, but I can't give credit. I mean, it's got to be whatever has been served.
He has.
Yes,
Okay.
he has over 200 days credit from what my
All
understanding.
right. Is that your understanding of the agreement here?
Yes.
Mr. Calhoun,
Yes.
if I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
So how do you plead to this? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Correct?
Yes.
Going to show you what's marked as State's Exhibit 1. Did you sign this? Understand it, discuss it with your attorney, or the contents all true and correct?
He signed it, yeah. He signed
Yeah,
it.
all this is right?
Everything's
Okay.
correct.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is hereby waived.
Yes, Your Honor.
I'm going to follow this agreement, if nothing further. And I'm going to find that you you have entered into an agreement with the state where the state will be disposing of this case by way of a Class A misdemeanor, a lesser included Class A misdemeanor to this second-degree felony of aggravated assault. And you are there is sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. As I find you are mentally competent to enter this guilty plea, it is freely and voluntarily made. And I am following the agreement. You are hereby found guilty beyond a reasonable doubt of this lesser included Class A misdemeanor, and you are hereby sentenced to confinement in the county jail for 180 days. Do you understand what has happened today, sir? You will be given credit for time you have served in accordance with this case. And according to what everybody is saying, it's 180 days, although somebody wrote something here that does not look like an 8. It looks like it's 0. We gotta fix that. On credit. Okay. You know, all ways to make a device. This is the most awkward design.
They didn't ask me, Judge.
Yes, sir. That's brilliant. But that's progress. All right, anything else?
We're making it. I think
I
that's
think
it.
that is done.
Thank you, Judge.
Now, I'm
That was on the-
not sure what happens on this. Does he get taken into custody and
They verify.
then they verify it and then he's released? I think that has to be done that way. I just don't think we give, yeah, you're going to take care of it. All right. You may have to be checked in and then they verify everything and then you get released. But it's a formality.
You be out.
So Michael just put in the chat, yeah, my guess is that it must have been a shaky case for the prosecutor, so they pled down to a Class A. Michael, once again, you and I to I was just forming that same thought as you typed it. You know, I always have to suspect that when these deals fall so much off of the initial charge, there has to be some issue there. An uncooperative witness, shaky evidence, there's something. Anyways, back to Judge.
Yeah.
Here's
Even time.
Yes, need your right. I need your.
She's gonna give it back to you.
Yes. Right here. Straight up.
Oh, you don't have to type that hard. You can more anywhere.
Just one, thanks.
Yes, Your Honor. Yes. Yes, now my, I'll check.
24 CR 777 is now called. The state of Texas versus Christian Armani Simeon. That's you?
Yes, sir.
Present with Mr. West, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Can, Your Honor.
In summary, this indictment alleges that on or about March 5th, 2024 in Jefferson County, Texas, you committed the first-degree felony of aggravated robbery, which carries with it up to life imprisonment. Do you understand what you're charged with here?
Yes, sir.
But that's not what we're going to be doing.
Right.
Well, we need to write all that down when it's.
I thought I checked the second because it drops it to the first and second. We're going to just, we're banning the aggravated parts, just going straight.
I understand, but it needs to get written here. Okay, defendant pleads to lesser included robbery.
Yes,
Is
sir.
that all right? Is that correct?
That's correct.
Initially?
Yes.
That would be a second degree felony, sir, which carries with it no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Second degree felony carries with a term of not more than 20 years, or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached in your case. You would be pleading guilty and placed on deferred or unadjudicated probation for up to 10 years in length. There will be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Sir.
How do you plead to this charge? Guilty or not guilty? Go ahead.
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence?
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer.
Sir.
All of this is true, so help you God.
So we go, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Please, Your Honor, yes.
If nothing further, I will follow this agreement and find you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I am not going to find you guilty. I will defer any finding of guilt so long as you follow the terms and conditions of probation that will be reviewed in a moment with you in the probation office. and you will be placed on probation for 10 years, and do well, it gets shortened to 1/3 of that length of time, which is how much? Three and a third.
3.5, that's close.
I'm gonna do math. He looked at me.
I don't have to think about it. I'm working meat all day. I don't work with numbers.
So you understand what's happened?
Yes,
Please
sir.
see the probation officer. Good luck.
Then you're good to go.
All right, let's rotate back to Judge Boyd for one more case before we enter discussion time.
All right. One moment. And are you Star Bright? Did you review the document entitled motion to enter adjudication of guilt and revoke community supervision and First Amendment motion to revoke community supervision with your attorney? Did you understand it? Are you the same Star Bright who was placed on deferred adjudication in 2024 CR 007-825 for the offense of possession of controlled substance penalty group 1 to 4 grams on September 17, 2024 for a term of 8 years? Is that you? All right, state.
Judge, will be proceeding on a violation condition number 2, specifically that on or about the 20th day of August 2025 in Barrett County, Texas, the defendant, Star Crystal Bright, did then and there illegally use a controlled substance, namely amphetamines, in violation of condition number 2.
How do you plead to that? True or not true?
And Judge will waive and abandon the remaining allegations.
Any objections?
No objection, Judge.
Did you understand by pleading true to violation of condition number 2, the court could find you guilty, grant the motion, sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. State, what are you recommending?
Judge will be recommending to waive and amend to DDRF. This is a probation's recommendation. The defendant's picked up a new drug case and our pretty much needs inpatient treatment, so DDRF will provide.
And defense, what are you requesting?
Judge, we're asking, obviously something different. We're asking that she be continued on deferred. She had, and be given outpatient treatment. The allegations are that she was scheduled for outpatient treatment before, failed to make 2 intakes, but was doing a different program, was not able to provide proof, but that was not disapproved by the probation officer.
Mhm.
She wants an opportunity to show the court she can do an outpatient treatment. She has 3 grandchildren. Her daughter needs help, 2 to 13. She has mental health issues. We're going to ask that she be managed by the MEC, supervised by the MEC. She understands she has a problem. She wants help with that problem. She was trying to get help herself. She's just has some problems herself getting that done. She believes that she can do an outpatient treatment and help her daughter take care of her kids. That'll give her some stability, if you will. I think it would give frankly, would give her an opportunity as well to build some self-confidence that she can do something with her family, useful, and for herself. She's willing to do that. She knows she needs help. She does have her mental health issues, primarily diagnosis and anxiety. That gets in the way of getting some things done on her own. With NEC supervision and her agreement to do an outpatient, whatever the probation says, outpatient treatment, she believes she can get this thing completed.
All right. So probation, I had previously recommended felony drug court for her. Was she ever interviewed by them?
She was not eligible, Judge.
All right.
According to
And-
the report.
All right. And do we know why she wasn't eligible?
It doesn't say on
It
here
just
why-
does not eligible.
Yeah, it just says it does not qualify for court summary, Judge. Doesn't give a reason, unfortunately.
All right. So here's the thing. I think you need a form of inpatient treatment. I don't know if DDRF is appropriate or not. Probation, will DDRF address any drug issues or just mental health issues?
It will address both, Judge.
But the wait time is long, correct?
Yes, sir.
Yeah.
Yeah. All right, this is what the court is going to do. The court is going to deny the motion. Alternate amend conditions. And what I'm going to want is I'm going to run a this is going to take place in custody. Also, I'm gonna ask for a re-referral to felony drug court. And if maybe you can talk to them, because they do have a dual diagnosis program. And they'll
Right.
make the determination of whether inpatient treatment or outpatient treatment is appropriate for you. And if not accepted, will SafeP address mental health issues?
Under the cognitive tract.
All right. So then if not accepted to that, then it will be SafeP. What I'm going to tell you is the wait time to DDRF is, how long is it? 13 months, 20 months,
It's about 4 to 6 months.
4 to 6 months. So court would deny the motion, alter main conditions for the following, and this is to take place in custody. There's to be a re-referral to felony drug court. Defense, you'll talk to them, see if they'll accept her. And if not accepted, then SafeP. Is there anything else?
I'll contact the drug court.
And probation,
Yes, Your Honor.
there is to be no unsupervised contact with minors. I'm sorry, what?
That would not let her take care of her grandkids.
I mean, she's not in any position to be doing that right now. Of course, that will change once if she's accepted in felony drug court will make that decision. If she's not accepted in felony drug court and she goes to SafeP, then she can always come back here and I'll reconsider it. But I can't in good conscience allow her to do that if she is not clean and sober and on,
So we
a
can
good track.
readdress it as
Yes.
appropriate. Right. All right.
Thank you.
Okay.
Okie dokie, friends. Good day in court. Nothing overly outrageous today. Typical things that we see. Things that make us shake our head. People that we hope get it right. All that sort of thing. But thank you all for spending the last 3 hours with me. Let's do something a little different, though, for hour 4. Let's discuss some stuff. First off, if you're a channel member, you can join me in this 4th hour. There's a link posted over in the Discord. That is where you find it, in the members announcements section. So if you're not signed up for the Discord and you're a member, you should fix that so you have access to that. And I will tell you, as I've told you before, if you are nervous about joining me online and don't want to show your face, which I know isn't everybody's cup of tea, you don't have to. Just keep your camera turned off and we can do it by voice. It's totally up to you. So there's a couple of stories that I want to get into. Pull them up here real quick. There we go. Okay. So the first one is a follow-up to the Nancy Guthrie thing. That's Savannah Guthrie's mother. If you don't recall from the times we've talked about it last week, Savannah Guthrie is the co-host of the Today Show on NBC. Her mother lives in the Tucson area, here in the same state as the TCF bunker. And mother just got kidnapped, about 8-9 days ago now, at least supposedly kidnapped. And there's a ransom out. And this has been dragging on all week, and there's been a lot of plot twists. Well, at one point, though they then denied it, it was reported that Tommaso Cioni, who is the husband of Annie Guthrie, who is Savannah Guthrie's sister, Nancy Guthrie's daughter, he was supposedly questioned about what was going on. Supposedly they towed his car, but on Saturday they did more from the looks of it. Law enforcement was conducting a consent search at the home of Annie Guthrie, again Nancy's daughter, and Tommaso Cioni is the husband, the daughter of Nancy Guthrie, when they returned to her home Saturday night. Tom Winter, NBC's News national law enforcement and intelligence correspondent, reported on Today that investigators were conducting additional searches to check if there was any potential evidence missed during previous searches. Nancy Guthrie disappeared from her home after the family dropped her off following a family dinner at the home of her daughter Annie Guthrie and Annie's husband Tommaso Cioni on January 31st. Winter reported that since authorities have yet to identify a suspect or a person of interest, it appears investigators' focus is just to start at the beginning and see if there's anything where we can drive from it. Law enforcement was previously seen at the home of Annie Guthrie and Nancy's daughter for 2.5 hours on Saturday evening. They were seen leaving 10:30 p.m., appearing to take photographs in the garage. At the time, Fox News Digital observed a deputy loading a white case into the vehicle, which he carried inside earlier, along with what appeared to be a grocery-sized brown bag. So, this could mean many, many things, of course, but it certainly reads as though the implication is law enforcement at least suspects that there might be a family connection here. And I hope for the sake of the family there is not. But if she had dinner at Annie Guthrie's home that night, but supposedly went missing later and they're searching the home, then it seems they're at least exploring the possibility that she never made it home. Or that something went down at the home of Annie that later caused the abduction or something. No idea what. But it doesn't read all innocent. And again, I'm just some dude on the internet. I'm not making accusations. I'm just putting together breadcrumbs and asking the question out loud. Is there a family involvement here? And it seems to be at least suspected, doesn't it? Otherwise, what's the point of going to the house that is not the crime scene? The crime scene is Nancy's house, the mother, but they're putting in this time to go to the daughter's house. And supposedly previously they had looked at Tommaso Cioni and his vehicle. And there's supposedly a ransom deadline later today. But there's already been a ransom deadline that has come and passed. This is like a new deadline. So this is totally bizarre, this case, and I continue to keep an eye on it. It's not normally the kind of thing that that gathers my attention personally. It might just be because it's happening in my home state. I don't know. But it's got some twists and turns and some things that don't make sense. Law enforcement dropping the ball, not necessarily paying attention. The other night, the chief of police for the area was found attending a college basketball game rather than being focused on his job. I know that ticked a lot of people off. So there's a lot of weirdness around this thing. So I'm going to continue to keep an eye on it. But you let me know what you think in the comments. But I definitely question the legitimacy of the story now that she had been abducted. I think there might be more to it. But like I said, I suppose time will tell. But moving on from that, I ran across this morning that I want to share with you. This is from Courthouse News Service, and it speaks so much into what we deal with here in the LawTube community, both as creators and as viewers. We run across AI slop, for lack of a better way to put it, all the time. And here's an entire article that was written on this matter just a couple of days ago. Generative Justice, AI courtroom content could change how Americans think about the law. It's an interesting premise. I don't necessarily disagree with it, but let's see what it has to say. And you can see one of the things they cited right here. This is an AI-generated photo of this huge guy in a courtroom towering over everybody. Weird stuff. Anyways, the article reads, bound to a chair, an unnaturally large defendant struggles to free himself. A squad of armed sheriff's deputies surround him as a judge reads his sentence, 6,700 years in federal prison. Take these chains off and say it again, the convict rumbles. There are many videos like it. A courtroom erupts in cheers as a judge dismisses a case against a woman who saved her neighbor's children. A teenage offender laughs as her victim's family weeps. Sometimes there's a narrator who describes these salacious legal dramas to viewers on YouTube, Instagram, and TikTok. Many of these courtroom videos are racially tinged. Some of them are more convincing than others. All of them are fake, stitched together with an out-of-context clip or generated wholesale with artificial intelligence. AI, we are told, would change the world, solving age-old problems and freeing humans from the drudgery of menial computer tasks. And yet, so far at least, one of the main uses of this groundbreaking technology has been to produce an endless stream of online content. Well, of course it has. Michael, I think you and I were discussing this the other day, and it might have been on In the Blind, I don't recall, but like how most things, unfortunately, once it's created, people will find a way to get it into the adult store. AI, unfortunately, is no different, but let's continue. Commonly known as slop, experts warn it's eroding public trust and a shared sense of reality. We're going to have a real problem in our society because a civilized society is built on trust mechanisms, said Edward Delp, a professor at Purdue. If we can't trust each other or things we're getting from the government, I think it's going to cause a lot of problems. He has a good point there, though I think government trust is a bigger issue than just AI, but we'll go on. Some slop might seem benign. Take videos of celebrities hugging younger versions of themselves or of animals doing impossibly cute things. These endless videos can have a dark side. Research shows that even when fake content isn't full-blown fake news, regular exposure to it can still lead to cynicism and disengagement, a phenomenon sometimes called reality apathy. I'd be curious what that research is, but they didn't cite it. There's a less cute side of AI content. President Trump has become a prolific poster of it, using generative content to smear and embarrass his opponents. In his second term, the president has used the technology to create a racist caricature of Hakeem Jeffries as a mustachioed Mexican, a video of him as a pilot king dumping feces on protesters, and even mocking altered photo of a private citizen activist arrested in Minnesota. I get what you're saying, writer of this article, but you could leave the politics out of it. Focus on your point. Everything's got to go politics, I swear. Tools capable of producing realistic-looking content are now widely available to the public with little guardrails on their use. In 2023, Elon Musk unveiled his AI service GROFF, which allowed users on his social media site X to create fake images of real people. This month, after ICE killed Renee Nicole Good in Minnesota, GROFF was used to digitally undress her. Past 25 years, Delp has studied synthetic media manipulation and media forensics. In that time, he's seen a wide range in the quality and or harmfulness of these fake online media. Some of them are funny, Delp said. Some of them are not good. When AI is used to generate content like purported police body cam videos or courtroom CCTV footage, it has the potential to cause real social problems, Delp said. People will believe what they see, even if it's labeled AI generated. What may have to happen is all of these content providers, even police body-worn cameras, are going to have to be protected or labeled. Well, how are you going to do that? Curiosity. Guardrails are possible. Okay, explain. A wide range of companies are experimenting with tools like invisible watermarking, which embeds data about the origin into media, and cryptographic hashes, which could provide unique identifiers that also help provide provenance. Delp's doctoral students are working on this problem, helping insurance companies figure out how to authenticate claims. Yeah, but it's going to be a cat and mouse game. That's already been tried, digital watermarking and stuff, and there are tools that can remove that. So, good luck. Unlike some observers, Delp does not believe AI is a bubble that might burst. Instead, he believes that the technology will continue to receive buy-in and financial support in new and unforeseen ways. At the same time, AI will make distinguishing between real and fake videos increasingly difficult. I'm interested in looking at where this is all going, Delp said. We're going to get to a position where these things are getting better and better. For now, he says, the detection tools are still reasonable, but that the problem is most of the really good detection tools are not available to the public. Despite these issues, Delp believes education, not legislation, should be used to safeguard the public from harm. That's something Tori Noble, an attorney with the digital civil rights group Electronic Frontier Foundation, agrees with. In an interview, Noble stressed that there's a difference between a problem for society to tackle versus something there should be a law about. I agree with that. Too many laws. Well said there. I think that the content people consume online can, of course, affect their worldview, Noble said. I think there's evidence of that. I think that begs the question, what do we do? Speech created with AI is still speech, Noble says. She's cautious about implementing prohibitions on artificially generated versions of it. Instead, quote, I think social media and media training in general and media literacy are really important, she said. Trying to control what algorithms are able to show people is a bad idea because whenever you put the government in the position of what they can or cannot show, you end up limiting First Amendment rights. Well, that is very true, and that is always the struggle that we have in this experiment called the United States, is we have First Amendment rights and freedom of speech, but then we also have ways that it's manipulated, and it's a constant cat and mouse game that's never going to change. One of the first legal thrillers was Orestia, the Orestia trilogy, rather, written by a Greek playwright around 500 BC. Parts of it read like a heavy-handed TV procedural. In the third and final act, a man kills his mother in revenge for killing his father, King Agamemnon. The man is granted a trial by the goddess Athena. His defense attorney is the god Apollo. From the ancient plays to modern television, courtroom dramas have long shaped how the public understands justice, even when those portrayals are fictionalized, and even when they involve figures from Greek mythology. Power brokers know this. An amusing example from 1963, California Governor Edmund Brown criticized the popular legal procedural Perry Mason for portraying the Los Angeles district attorney as a helpless and bungling lawyer who regularly loses cases. In a recent study from the University of Tennessee at Chattanooga found that media portrayals can negatively influence how people view policing and criminal justice, particularly for people of color. Likewise, in a 2006 study, William and Mary Law Review found that TV news, which has a profit incentive to hook viewers with titillating accounts of monstrous crimes, can skew Americans' perceptions of law and justice, ultimately leading to a more punitive, tough-on-crime policies. Still, Americans love good legal drama when it's not their own. A 2025 YouGov poll found that half of Americans enjoy true crime content. Can confirm there's a reason why this channel has done so well in the mere 15 months it's been around. People like this content. In other words, even without generative AI, courthouse and true crime media can get into tricky ethical territory. I would agree with that. There's a reason why the way we do videos here is not what is typical in the LawTube space. Most channels will try to sensationalize it with crazy thumbnails of outrageous expressions on judges' faces and defendants who are cowering or yelling back, and we just don't do that here. But it's true. It garners views. Nate Eaton, an Ohio-based YouTuber and Idaho-based YouTuber and a journalist, said he regularly grapples with responsibilities of online content in a world where clicks translate into cash. On his channel, East Idaho News, I've seen that channel, Eaton produces a series entitled Courtroom Insider that discusses the ins and outs of courtroom sagas. It began with coverage of the Lori Vallow trial, when he would produce a special recap at the end of the day. The numbers went through the roof, he said. Since then, he continued delving into other well-known cases. The AI-generated videos are a nuisance, he said. Can confirm they are. Some of them have millions of views, and the headline is so catchy, he said. You won't believe what Brian Koberger whispered to his attorney. It looks real, and the pictures look real, but then it's an AI voice reading it. If I was just trying to churn as many videos out a day, there's a million court cases I could be covering. I'm specific about the ones I choose. See, now Mr. Eaton and I align there. It's the same thing. I'm very careful about what we cover, what we show, what we choose. And I try real hard to give you good stories and, yeah, stuff that's intriguing, but also educational, but not over the top, ridiculous, and certainly not fake. There's a lot of that out there. Eaton says he tries to distinguish himself as a responsible journalist. That means not focusing exclusively on cases that drive web traffic, as well as building up trust, and not just with his audience, but with attorneys. I want to be able to educate the public on how the court system works, why it works, what it does, but also use terms that are easy to understand and make it compelling content. I don't want to be boring. A lot of times court terminology is boring and hard to understand. I want to be able to explain things clearly to the audience, along with giving victims and family members a place to talk. Eaton may be doing his best, but not all content creators are. Can confirm. And AI is making it easier than ever to manipulate and even entirely fabricate authentic seeming media. So far, there are still few legislative or corporate protections to prevent these tools from being misused. Late last year, OpenAI unveiled a social media platform that seamlessly produces and shares videos based on text-only prompts. The project quickly took heat after creating fake content of dead celebrities, as well as media that have infringed on copyrights. In January, YouTube CEO Neil Mohan wrote in the company's blog that it would crack down on what he deemed low-quality, repetitive AI content. More than 1 million channels use AI daily, he wrote in a post. Now, that's funny, because if you read the other things from Neil Mohan and you pay attention to the direction they're taking YouTube, they push their AI tools upon us. Every single day, there's an email from YouTube. Have you tried this AI tool? Are you aware that AI can do this for you? Let us use AI to help you do this for your channel. We'll suggest titles for you. We'll write descriptions for you. It is all over. And it is forced upon us practically, but yet he's claiming that he wants to crack down on AI content. So I don't believe him. Anyways, these days, anyone with a free account on an AI generator can generate a 30-second video of a fake courtroom, Delp said. And with a little money, those videos get longer and more convincing. The tendency to believe these videos can be strong, Delp said. That's especially when they confirm existing assumptions and beliefs. For example, that criminal defendants are inhuman monsters who must be chained in court as they're sentenced to thousands of years in prison. We're going to come to a point where the average person seeing content online is not going to know whether it's real or not. And I think a lot of people who watch a channel and it confirms what they already believe will have a tendency to believe the video. That's going to happen all the time. So I wanted to share that story with you because there's a whole lot of truth in it. And I believe that the audience we have here is a good audience. It's an educated audience. I think you guys tend to know the difference between what's real and what's imaginary, though in the same respect, we have had some instances where frankly, we've all stumbled across things where we've been fooled by it because it's easy to do. We've had situations where there's people out there impersonating the judges, for example, using their names and their channels so it looks like it's the judge's channel, but it's not. I've personally seen some AI videos where they've taken the real judges that we see, and they've put them in short clips doing things that they're not supposed to be saying or would never say. So there's that. This is a real problem that we have, but it's interesting that it got so big of a write-up on the Courtroom news service. And this guy that they interviewed as well, who's also a YouTuber, everything he said is right. It's very hard to be out there and do this content and do it like legitimately and have it stand out. It's a mess out there. But my personal commitment to you is to continue to do content that proper and that is real. Now, I will continue to refine how I present it to you. I think there's continually better ways to tell stories. So, I've always believed that the day you stop learning and the day that you stop getting better should be the same day that you pass. So I'll always strive to do it a little better and to make a better presentation, a more compelling presentation. But what I will never do is make it wrong or make it false. but it's, as the article pointed out, it's everywhere. And somehow we're going to have to figure out as a society how to deal with that. And I don't know what that answer is. You know, they talked about educating people with media literacy and whatnot. There's a lot of the population that's struggling with regular literacy, let alone media literacy. So that's a tough one. But it's not wrong either. You know, you have to take the time to really analyze what you're looking at, not take everything at face value, not read the headline of a story and believe that that's the truth or the whole story. Not look at a video that gives you one viewpoint and say, okay, this is what I believe now, but what are some alternate viewpoints or what are some other ideas? So we do have a media literacy problem. That is true. What's the solution? I don't know. This is just like Sidebar where we talk about things but solve nothing. So there you go. Well, friends, that's pretty much what I had for you for today, so we'll cut it a little bit short. We will be back tonight, though, over at In the Blind, so do me a favor on your way out and check out that channel and subscribe to it if you haven't already, but we'll be there tonight, 7 p.m. Eastern, 4 p.m. Pacific. That is me and Michael Groff, and we will have an hour-long show where we debate and discuss a couple of topics, plus my personal favorite at the end, the true-false round, so please do join us for that. And we'll be back on this channel tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific. If you're a channel member, you can join us a half an hour early. So go have yourselves a great Monday, everybody. Take care. God bless.